Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, February 19. So we have about 8 hours of requested time for oral arguments. Obviously, we cannot accommodate that. So please only ask for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind we've read your briefs and we are fully familiar with those arguments. People v. Profit. That matter is submitted. Matter of Zion, that matter is submitted. Kale v. 686 Broadway Realty. 525 Galloway v. Arthur Clinton. I'm sorry, I missed one. Who's the other? 68615. How much? Now we got everyone? 5, 2, 5, 5, and 2. That's it? Okay. Galloway v. Arthur Clinton Housing. 4, 2, and 2. Schultz, did I miss someone again? I'm sorry, I'm on a roll. You represent who? Okay. 4, 2, 2, and 4. Schultzman versus 19 East 72nd Street. You have a cross? So, okay. And? I'm sorry, who do you represent? 5 minutes? 4, 2, 4 and 2, 3 and 2, and 4. People v. Hakeem A. Those matters are submitted. All three. STA Parking v. Federal Insurance. 6 and 2, 6 and 2. Southgate Owners Corp v. Esposito. 525. Graham v. City of New York. I'm sorry? Yes, sir. There is no respondent. The city is not here. Oh, well, you got to get up. How am I? No, don't worry about it. I should have known. Since you were sitting there, I should have known. My apologies. Mr. Graham, how much time are you requesting? Okay. And city? Yeah. 5, 2, and 4. People v. William Caruth. Matter is submitted. Enriquez v. the City of New York. 424. Healy v. Kruger. 424. Hearns v. Beacon, Apartments. 52552. Staten v. City of New York. Is there an appellant? Did you still wish to argue? Or did you wish to submit? 1 minute? 2 minutes. Joyce J.D. Limited versus Yolanda Management. 424. People v. Cooper. 525. Contempo Acquisition v. Dawson is submitted. First case for argument is Kale v. I'm sorry. What case would that be for? Contempo, that matter is submitted. But thank you for coming. We appreciate it. First case for argument, Kale v. 686 Broadway Realty. Whenever you're ready.
May it please the court, Jessica Smith for defendant appellant Chimenti. In the context of this case, Chimenti was merely a separate prime contractor. It was not a general contractor with respect to the asbestos work. As a result, it should not be held liable pursuant to the labor law, as it's not a proper labor law defendant. Chimenti's contract explicitly excluded asbestos-related work. The plaintiff in this case was employed by Branch, who was the prime asbestos contractor. He was injured inside the containment area while performing preparation work for asbestos. Since it's completely exempted from the contract,
Counsel, didn't Chimenti create safety zones, cover holes, erect barriers, and prepare the area for Branch to work?
that was a handoff between two contractors.
Would that be a yes?
They did, however,
No.
I would just,
Counsel, would that be a yes?
they did that, yes. However,
Yes?
I did say yes.
Ah.
They did that, yes. However, I do want to point out the fact that Tello, who is the supervisor, actually testified that he was responsible and did in fact cover the holes. Additionally, plaintiff was performing, according in his own words, this plasticizing work at the direction of his employer. This plasticizing work involved wrapping every single piece of plywood that was lining the floor with plastic. So necessarily, once Branch took over, they were covering
So
all.
Chimenti made the holes?
The Chimenti did not make the holes. It's a little unclear in the record, but there's some indication that during demolition, the hole was created by one of the Chimenti subcontractors, which then revealed the presence of this asbestos roofing material underneath the cement, which required Branch to come back to do additional remediation work.
Did your client inspect and prepare the area for the asbestos removal?
I'm sorry, I just missed
Did
the,
you inspect and prepare the area, your client, for the asbestos removal?
so the client went through and it did check the coverings on the holes, and he said that everything was secured when they handed it off to Branch. But if you actually look at the testimony from Norgera, who was the supervisor for Chimenti, he mentioned that they were actually doing this in accordance with Branch's standards. He walked through with the Branch foreman who approved it for Branch's use. So everything that they were doing was actually required by Branch. So this was part of two prime contractors' coordination with one another. The asbestos work was entirely separate. There's this explicit contractual provision eliminating it. So from their work. So how could Chimenti possibly?
Was Chimenti the GC on the site?
So I think that's a more complicated question. Chimenti was the GC for the purposes of the
Well, it
build-out.
wasn't a complicated question at all, so the
Well,
answer is yes.
I mean-
Chimenti was the GC. And so you're stating that Chimenti would oversee the site with Branch, but if Branch said something that was incorrect or that could cause an issue, that Chimenti would simply go along with Branch?
Chimenti did not oversee Branch's work, and that's abundantly clear. Branch separated this
They
area.
didn't oversee the asbestos work, but they did oversee the whole project.
That did not include the asbestos work. It's two separate things. Now, I know there's much ado is made in the respondents about it's the same project, but we have a contract that specifically allocates responsibilities to different people.
But what
and
I'm not understanding is Chimenti is responsible for the site, for the construction site. Are
it's
they not?
I'm sorry.
Yes or no?
It's responsible for the build-out portions of the site. It is not responsible for the asbestos work area, which was cordoned off at the time of plaintiff's accident.
But Scamenti was the one who prepared that work area for the asbestos removal, right? You already admitted to that. You already conceded to that.
So they prepared it by covering holes as they were required to do for a handoff. However, it's exempted from their work. The owner never delegated them authority over.
They're not exempted. Why are they exempted for responsibility for the holes?
They are.
If they didn't make it, it was done under their supervision. They're the ones that are preparing some sort of safety answer to those holes. If they're the general contractor, how do they get out of responsibility for that?
They're not the general contractor with respect to the remediation area, and that's made abundantly clear by their contract. And this,
Okay, but they are responsible for the holes, is that correct? they were the ones, your client was the one that actually made the holes, is that correct?
My client did not make the holes. There's some indication in the record that a subcontractor made these holes during demolition. It's not abundantly clear in the record exactly who made these holes. However, what is clear is
But
that
I
Okay.
usually think about general contractor, even if the holes were made by a subcontractor, it is something that the general contractor would be responsible for under the labor law, isn't that so?
if they had ability to cover the site, to control safety at the site, yes. However, we know Branch took possession of this area, and at the time they were engaged in asbestos remediation work. We also know that plaintiff is saying at the time it was not secured. We know Branch was lifting up all of these plywood pieces to plasticize them. So it was then outside of the Strumenti's control once Branch took over and they altered the coverings here.
You have
So-
time on rebuttal?
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. Shimetti is 100% liable as the general contractor.
Well,
Not
they're stating, you heard what she said, that they were only responsible for the build-out, they were not responsible for the asbestos removal.
But this isn't about the asbestos removal. This is about preparing the area prior to the abatement taking place, which they've admitted they were responsible for preparing
Well,
the.
did or did they not, or were they or were not the ones who made the holes?
Well, it's not clear which subcontractor of Schimetti did it, but the only subcontractor, the only people on the site prior to the abatement were Schimetti subcontractors. And so whether it's Park or somebody else, they were responsible for preparing the area before the asbestos abatement went forward
So if
and
it was a subcontractor,
of Schimetti.
would they still be liable?
Of course, if it was a Schimetti subcontractor. In addition, the record is patently clear that not only did they have the overseeing the job site, but that they had the daily presence at the site. Not only did they prepare the area for the work, but actually, Mr. Nigel, who
But they're really not even supposed to go into the asbestos area, isn't that true? The place that's cordoned off to do the asbestos abatement, that's under Branch's purview, and other contractors aren't supposed to be going in there, isn't that so?
Not according to the record, and this happened before this. This happened before. The floor was prepared before. In fact, Mr. Nigel couldn't answer. He said he was responsible for maintaining the floor, making sure that all the coverings were fastened, and making sure the covers the holes were covered before the abatement happened. So this was before the tent went up and the abatement started. They were allowed on the scene because it was their project and nothing had taken place yet. So Mr. Nigel said, I prepared the asbestos abatement area, 713 of the record. I'm responsible for covering the holes and securing them, but he couldn't answer. He inspected it right before they started the abatement. He couldn't even answer the question whether the plywood was fastened before he handed it over to Branch at 1830 of the record. In addition, Tello testified from Branch that when he was given the site, there were 3 to 4 holes that were present that weren't covered by Schimetti, and Schimetti's admitted that they were supposed to do this. I think what's really
Was
relevant,
there a site inspection, a site safety coordinator other than Chimenti?
I don't believe there was a site coordinator other than Schimetti.
Site safety
I
coordinator?
don't believe there was a site safety coordinator.
Chimenti was in charge of site safety, am I right?
Yes, and in fact, it's set forth.
They had the authorization to stop work as well?
Correct, Your Honor. If you look at 880 of the record, there's a Schimetti corporate safety and health program, which is very detailed and very comprehensive. It sets forth many things that show their responsibility and their liability and their control of this area prior to the abatement. For example, not only do the Schimetti safety rules have to be followed, but they are responsible for installing covers on the floor, labeling them, making sure that the garbage chute, the very hole that plaintiff fell through, the garbage chute, is supposed to be covered, labeled, either hole or cover. Nigeria testifies to this. They're supposed to cover the garbage chute. They had authority to stop the
Well, that's why I
subcontractors'
was
work.
asking your friend, because she stated that Branch was responsible for all of this, and that Branch was the one that did the walkthrough and made the determination as to what should be done or what should not be done.
Committee did that with Branch prior to Branch starting, and
She seemed to suggest that regardless of what Shemeti thought was proper, that it was Branch's determination which controlled.
well, it's committee's determination because they're contractually responsible for the site. It's not Branch that determines that. It's committee by their own testimony that they're responsible to hand over the floor without holes, with plywood covering it and having it marked. In fact, I'd like to show you on the record, if you really want to see what this hole looked like prior to Branch getting there. If you look at 875 of the record, this is before Branch gets there, 875 of the record. There is a gaping hole that was created by either Scometti or Scometti subcontractor, a gaping hole. This is what it looked like before Branch even got to the site. So it's 100% within Scometti's control by their own admission and by their site safety regulation.
A little while ago, you started to say what you thought was particularly relevant in the 10 seconds. You want to tell us what that was? Do you recall?
Well, not only was it the corporate safety and health program, but I think that this is not such a nuanced issue. If you look at Maracho, which is we cited in our brief, you have a situation where an owner contracts with an asbestos company, but the general contractor, well, actually it was a construction manager, but regardless, the general contractor was held responsible because they were responsible for preventing accidents at the site and preventing injuries. The same thing as Walls. Walls really is particularly relevant because in Walls against Turner, you have a situation where the owner contracted with the subcontractors, but yet the construction manager was held responsible because they're responsible for the site. So this,
you.
thank
you
you.
very much.
Thank you.
Good afternoon, Your Honors. Julia Audibert with Wilson Elser for the owner defendant respondents. I'll just start by noting, as we raised in our briefs, that any request by the by Scamenti appellant for the reversal of the granting of conditional indemnification, conditional contractual indemnification to the owners is not within the purview of this court, as it was not attached to the notice of appeal. Further, as to the denial of Scamenti's motion for the cross claims on contractual indemnification, that order should be affirmed to the extent that it's in front of this court. As Scamenti admitted, they were the general contractor for the site. They were entirely responsible for the safety of the build-out of the project. I will note that in response to the Branch not being a part of the same project, the contracts for both Branch and Scamenti name the project that they're working for as the Jones Distillery project.
Counsel, what about the fact that Scamenti claims that their contract specifically excluded any asbestos abatement work?
Certainly. So to the extent that they argue, so section 8.5 at 829 of the record states that they're excluded for the discovery, presence, handling, removal, or disposal of asbestos. And for the purposes of contractual indemnification, that is irrelevant. No one's saying that they are an asbestos subcontractor, but they were responsible for the preparation of the area prior to Branch arriving. And I'll rely on, as the plaintiff's counsel also stated, the holes were there. They were in charge of preparing them. They admitted that they were in charge of preparing them. So I won't belabor that point for you. And then,
So, counsel, going back to the testimony of Cesar Tello Ortello, the supervisor for Scamenti.
yes,
He testified that on the first day that he visited the area, this is before the accident, he saw 3 or 4 uncovered holes, and that he and his workers covered the holes subsequently. What relationship does that have? Does this testimony have to the plaintiff's accident?
I would like to answer in terms of contractual indemnification, as that's our sole argument here. So as far as their covering of the holes,
Do we have a timeline?
sorry.
We don't move that.
The timeline was, if you're asking about timeline, Branch arrives, and then I believe it's about a day or 2 days later that plaintiff's accident occurs. Does that answer your question? Or are you asking in relation?
When does the Scamenti supervisor acknowledge that there were uncovered holes, that he and his people then took the responsibility for covering?
Oh, I'm sorry, the branch's supervisor, yes? Immediately, he says that they expected the holes were to be
Sorry,
covered.
it's a branch supervisor. Did I make a mistake?
Either way, Tello was the correct name, so I understood. They expected the holes to be covered, and as soon as they arrived, the holes were not covered. So they hadn't completed any work yet. Branch hadn't started the asbestos work when he noticed that the holes were uncovered, and it was, again, Scamenti's responsibility to provide for this secure.
Tello worked for Branch, your client, Branch.
I'm sorry, no. Tello
Tello
worked
worked-
for Branch. My client is the
You
owners.
don't represent Branch, right?
Correct. I represent the owners.
Right, thank you.
Okay. Is that all? I want to make sure that that's clear. Okay, thank you. If there are no further questions, I will rely on my papers. Thank you.
Good afternoon, Your Honors. May it please the court. Matthew Lavoie of Woodsmith, Henning, and Berman.
You represent Branch, is that
That's-
correct?
that's correct,
I
Your
think the question was to you in terms of the timeline and Branch is coming on the scene and the site.
I believe counsel had it correct. I think it was, as soon as they arrived, they noticed that these holes, which Schmidt were supposed to cover, were uncovered before they even started their work. I just want to make a couple points, Your Honors. Schmidt argues that it was not a GC with respect to the asbestos work, but this case law is against that. And this court made that finding in Perez and also in Moracho, in which this court rejected that argument. It does not matter that Schmidt could not specifically supervise the asbestos work. As GC, Schmidt had the responsibility to prevent fall hazards at the site, including the hole that plaintiff stepped into.
Well, as you heard, Shimenti claims that it was totally your responsibility, Branch's responsibility in terms of the asbestos removal because it was a pass-off, a handoff to Branch to do that portion of the work.
It was a handoff, correct, Your Honor, but still, that does not negate their responsibility as GC to prevent fall hazards. This was not, plaintiff didn't suffer some asbestos-related injury. This was a fall injury, and as GC, it's Schimenti's responsibility.
To the extent that Branch covered that Mr. Tello testified that he and his people, Branch workers, covered the uncovered holes, does that then mean that Schimenti is no longer responsible for the uncovered holes? Or the shifting of the plywood that allegedly caused the plaintiff to fall through?
No, Your Honor. As GC, they have responsibility for safety and to prevent fall hazards over the entire work site. Just because there's an asbestos project on the site doesn't negate that responsibility.
No, but that's not my question. It's not about asbestos. I agree with you. We're not talking about asbestos remediation, right? I'm saying that if there were uncovered holes that arguably Schimenti should have covered, and Branch then covered those holes, so is Schimenti no longer liable for failing to cover the holes?
No, Your Honor. It's still, as a GC, you have the responsibility to prevent fall hazards, and they didn't do that here. Regardless of whether regardless of whether Branch came on site and started their work or covered any holes, when Branch arrived, there were uncovered holes. Therefore, Schimenti, that was their responsibility, and they failed.
I guess the issue is Branch took it upon itself to cover these holes, and then it's the same hole or one of these holes that the plaintiff fell through. So therefore, does it now become Branch's responsibility because of the way in which they covered the holes?
I think there may be a shared responsibility potentially, Your Honor, but that does not negate Schimenti's responsibility as the GC for safety over the entire site.
Thank you.
Thank you.
So just I want to first address the indemnification issue that it's not before the court. It is before the court. The appeal was from the denial of the motion to dismiss all cross claims, which included indemnity, the oral arguments in the record. And in fact, their opposition to that motion on the indemnity piece is in the record. So there's no issue with that. Specifically on indemnity, that is a creature of contract. The contract does not include asbestos work. They did not assume a risk to an asbestos worker because of that language. So even regardless of 240, contractual indemnity still must fall because it is a creature of the contract itself. Moving on to...
Conflating issues once again, right?
I'm sorry?
You're conflating the issue of asbestos remediation with overall site safety.
I don't concede that. I don't think so, especially with respect to the contractual claim, because the contractual indemnity claim is based upon the contract, which excludes asbestos work. that would include a risk to an asbestos worker because that is not within the context of the contract. So regardless of what you say on 240, still the contractual indemnification has to fail. And I also want to point out Debrino, which I highlighted the Court of Appeals case to everyone yesterday. In Debrino, there has to be a direct connection. It can't just be any action that occurred at the site triggers the arising out of. So that's definitely something to keep in mind.
Counsel, with regard to the indemnification claim, the order from the Supreme Court on that, is that related to the motion papers that's before us now?
Yes, because it was our motion to dismiss the indemnity claim that was denied, that was appealed, and we go through a variety of reasons in our brief. Well, even if that was not the case, it still should be considered by this court. But it was our motion to dismiss all cross claims, which included the indemnification claim, and that order was attached to the notice of appeal and is before this court. Now, I want to.
Was it noticed? Was it noticed? Was that order noticed in the appeal?
The order, which order?
The order that you are seeking this indemnification denial, was that noticed in the appeal?
Yes, because it was the denial of our motion to dismiss the contractual indemnification claim. We made one motion to dismiss all claims, including the cross claim, which was the indemnification claim. An oral argument, and that order is in the record before the court.
So you filed a motion, you filed a separate motion raising the issue of indemnification. But the issue is, did you reference or incorporate the determination by Supreme Court denying the motion for summary judgment on the contractual indemnification?
Yes, it's in the same order that denied our motion in full. What they're saying is so the court issued 3 orders here, all in the same motions. There's actually 5 order filings. Some of them were labeled interim order. One of those interim orders granted contractual indemnity. However, Chimenti's motion was decided in a later order, and that denied its motion to dismiss plaintiff's claims and the cross claims, which included the indemnity. It was all part of the same oral argument, which is in the record before this court. So to decide whether
But isn't it the other order that's really has the issue of the indemnification?
No, because our motion sought to dismiss that claim of indemnity. So the court denied our motion to dismiss the indemnity claim. So that is in the order before this court. So it's definitely before this court. May I be heard very briefly on the plaintiff's claim? I see my time is up.
Yes, thank you. Thank you all. Galloway v. Clinton Housing Development.
Good afternoon, Your Honors. May it please the court, my name is Michael Kazoras from the Law Office of Eric D. Feldman on behalf of the defendant appellant Natias Construction. Natias was a contractor hired by the property owner Belmont Arthur to do a renovation at a building. In January of 2018, there was a stop work order due to subsidence and a dangerous condition of the foundation. Now, in February of 2018, there was a partial rescission of the order. And Natias has been quite open and frank that, yes, it did perform additional work at this site in connection with attempts to remedy that condition back in 2018. However, it's undisputed that Natias performed no work whatsoever at this site in
Counsel,
2019.
the barricade that's sort of on the sidewalk, was that placed there by Natias?
It was placed there by a subcontractor hired by Natias.
So would it therefore be Natias' responsibility, ultimate responsibility?
The barricade would be its responsibility, but the barricade had nothing to do with the plaintiff's accident. If you look at the photographs,
Well, did it not narrow the space on the sidewalk?
it narrowed the sidewalk. However, the defect is right smack in the middle of the sidewalk. There's an equal distance between the defect and the barricade and the defect and the curb. It didn't funnel
Does
the
that matter
plaintiff.
in terms of whether there's a question of fact as to Notius's responsibility here?
I don't believe it's a question of fact. It might be an issue of law, but I don't think it's a question of fact because the barricade didn't funnel her towards the defect because she had plenty of space on her left or her right to maneuver around this barricade. The barricade took up a
How is
very
this case different from Colton versus New York City?
well. I'm not familiar specifically with the facts of that case, Your Honor, but I do recognize that there are cases where barricades funnel pedestrians toward towards a defect, which can be a
And
determination
is the
of
language
liability.
that it has to have funneled the plaintiff towards a defect, or is it that it had to have obstructed the sidewalk in a way that narrowed the sidewalk?
My understanding of the law is that it has to guide the plaintiff in the direction of the defect. Here, there was plenty of room on the left or the right for the plaintiff to avoid this defect had she seen it. This defect.
Counsel, if I may.
Yes.
Just to continue this line of inquiry, going to Colton, I'm going to quote, so it'll be easier. It says, although the defendant in that case was not responsible for causing the breaks and irregularities in the sidewalk, it did have a duty not to create an unsafe condition when it narrowed the sidewalk by erecting the plywood cover around the building, and to the extent that it may have increased the risk that pedestrians might trip on the broken and uneven portion of the sidewalk. And then it says, tribal issues of fact exist in this regard that preclude summary judgment dismissing this aspect of the complaint. So now that you have some understanding of Colton, how would your situation be different where the sidewalk was in fact narrowed? And I would also say that the contract did say that you would keep the site clean and safe, which includes the sidewalk and the street.
Right. Well, to answer your first part, if Your Honors look at the photographs, I think it's
I have a copy right here in front
okay.
of me.
I think it's pretty clear that there was ample room. I mean, at one point does it become an obstruction?
But does that question that you raise equal a question of fact that can't be decided by your motion for summary judgment?
Your Honors, I think it can be decided. There is case law that says that the court can look at photographs and make a determination as a matter of law if it's clear.
Right, but in terms of Colton, it stated in Colton, again, it was the condition narrowed the sidewalk, right? And so the erection of the plywood or whatever that was narrowed the sidewalk. And according to Colton, the issue is whether it therefore increase the risk that pedestrians might trip on the broken and uneven portion of the sidewalk. So it's not that it funneled, it has to funnel the individual pedestrians to that particular uneven portion. It's just the fact that it in and of itself was narrowed. Now there's less room to walk, and therefore it increases the possibility that they're going to trip over that uneven portion of it.
Thank you, Your Honor. I see my time is up.
Good afternoon, Your Honors. May it please the court, for respondent Ms. Galloway. Plaintiff respondent's argument is very brief. Firstly, it seems like the motion for summary judgment is based mainly on a stop work order, which has been conceded to be only a partial stop work order. And in fact, the testimony, I think, is fairly clear that work continued on the site during the duration of the partial stop work order, which encompassed the date of this accident. So at the time of this accident, the contract was still in effect from the plaintiff's perspective, and the duty to keep the sidewalk safe was still in effect by contract and also by Section 33 of the Building Code, which provides that a contractor has to
What
keep.
type of work was ongoing during the course of a stop work order, counsel?
It's actually not clear. There's contradictory testimony from the defendants as to whether or not they were still working in the area directly behind the barricade. It also may be the case that work was only happening in the corner where there was some structural difficulties, that the stop work order was rescinded so that they could do work there as well. But regardless of which work it was Notias that would be doing the work. So to that extent, their contract was still.
Do you agree with the argument that if there was no work going on whatsoever pursuant to the stop work order, partial or not, that there's no liability?
No, I don't agree with that at all, actually. I think even if that were the case, there would still be liability because the fact is that if you look at the photos, the sidewalk is decreased by a third to a half. The defect that she tripped on is located between a sidewalk, a tree well, and the barricade, which is an extremely narrow area of the sidewalk. And the contractor had notice of these conditions, the tree well and the defect. In fact, I questioned the appellant's witness, and he agreed he could see the defect that she tripped in well prior to the contract actually being in effect. He also agreed that they had surveyed the sidewalk. There was a plot plan that showed work needed to be done around the tree wells at a time when the defect was there, so they certainly had notice of it. So I'm arguing that that Notias maintained a special use. They were an occupier of about a third of the sidewalk there, and that they maintained it negligently, even if they weren't on the site.
Query, counsel, was Notias supposed to repair or replace the sidewalk once the project was done, once the interior work was done?
Oh, yeah, ultimately. In fact, by the time of the depositions, they had already done that.
And what about counsel's argument that there was plenty of room to avoid that defect? That the plywood barricade did not prevent plaintiff from, it did not force plaintiff to walk over that defect in the sidewalk?
I mean, I think it's an argument, but I don't think based on the precedent that it's a great argument. I think this court in a case called Hunter against the city of New York upheld liability in a case where the sidewalk was significantly narrowed and the pedestrian was channeled into that area where the defect was. The other thing is it happened at night, and Miss Galloway's blind in one eye. So I know she maybe should have seen it, but she had a little bit of a difficulty seeing
I
it.
was going to ask about open and obvious because it's kind of clear the sidewalk is a mess in terms of, the defect in the sidewalk. But it did occur at 1 a.m., so.
Thank you.
Hi, good afternoon, and if it may please the court, Chirag Tsatsangi from Galvatucci-Clark for the defendant respondent Arthur Clinton Housing. Your Honor, first and foremost, I'd like to echo what I think was already been said. However, Notias is not entitled to dismissal of Arthur Clinton's contractual indemnification claim or common law indemnification and contribution claim. As what's been noted and what the Supreme Court has noted, there are factual issues for the jury to determine, and this is not a matter to be resolved on summary judgment. Your Honor, I do echo what you said earlier on how was there enough space for the appellant for the plaintiff to have walked around, or probably have not seen that, and I believe appellant also requests that in their reply. However, I feel like they're requesting certain things that should be given to the jury to decide as a matter of fact. Could she have walked around it? Could she have seen the barricade? I believe that's a question for the jury and a question of fact, not to be decided on summary judgment.
Was there any requirement that this barricade be built?
There was no requirement, Your Honor. However, it was per the contract of Notias. They were responsible for sidewalk maintenance, and I believe that's why they constructed it, although with a subcontractor. So that was their purview.
Thank you.
Thank you, Your Honor.
Your Honors, I think with respect to the barricade, I mean, part of the issue is special use of the sidewalk. Under the case law, owners and occupiers of the adjacent property can make special use of the sidewalk, not the contractor. So in this instance, there was nothing per se negligent about the existence of the barricade. And to the extent that Notias had to maintain the sidewalk, it had to maintain the sidewalk while it had an active permit and was doing the work. On March 8th, 2019, Notias sent a letter.
Where is that stated in the contract? I know that there was a letter that said we're not going to be doing any work. and we're not going to have anybody on site. We're not going to renew the permit, at least for now, because there's a stop order. But where does it say that if work was not undertaken during any particular period of time, then there was no responsibility for the sidewalk? And
Yeah, it says it in the letter, and the fact that they were doing, when they were responsible for the sidewalk when in connection with the project. When the project was suspended for a year and a half because of the stop work order, even councils.
But if it was negligent to put up the barricade, the fact that you are off the job because of the stop work order doesn't eliminate your responsibility for the negligently constructed barricade.
Well, if the court finds that the construction of the barricade itself was negligent, then we don't have an argument.
If it created a dangerous condition by narrowing by directing where a pedestrian would have to walk. I don't mean that the barricade per se was negligently constructed, but its effect was to create an increased risk to someone passing by.
If the court finds that Natius is negligent because it narrowed the sidewalk and created a dangerous situation, then it wouldn't matter what Natius' responsibility was after its permit expired, because then it would have created the condition. But it's our position that it didn't in this instance.
Thank you.
Thank you.
Schultzman v. 19 East 72nd.
May it please the court, Glenn Kaminsky with the firm Morrow Lilling, the party counsel for the appellants 19 East 72nd Street and Brown Harris Stevens. Respectfully request this court to reverse the Supreme Court and dismiss all claims and cross claims against my clients. 19 East and BHS were entitled to summary judgment as they demonstrated that they had absolutely nothing to do with these tree wells. John and Derlarga.
How did you establish that you had nothing to do with the tree well?
Glad you asked, Your Honor, because I was just about to say. Two witnesses, John Delarga, Aiden McGoldrick, starting with Mr. Delarga, who was 24 and a half years with BHS, was clear that neither BHS nor 19 East had anything to do with the wells or grades.
Mr. McGoldrick said that he had been, he was hired after the installation, right?
He was?
Yeah, he said he was hired after the installation, right?
Yes. So he was.
Delarga, go ahead.
So he was hired after the installation, so obviously he can't testify to what happened before. But what he did do is a comprehensive search of the records that existed from in the preceding time frame and found that there was absolutely nothing there.
McGoldrick?
McGoldrick, yes.
So McGoldrick provided an affidavit stating that the office was not in possession of any installation or maintenance records involving the tree well or the tree guard from 2000 through 2008.
Correct.
Not in possession of. Does not in possession of, is that sufficient?
Yes. Yes. He's saying we don't have it. And no one says
We don't have it doesn't mean that
they don't
it didn't
exist.
occur.
He looked, that affidavit goes on to say he looked in drawers and cabinets and such.
Well, it's not the same as if someone came in and testified, oh, yes, I remember when that tree well was installed, and it wasn't installed by us.
And that together with his testimony that he didn't know who installed it because he was hired after they were installed.
All of this I agree. And I'm in a bit of a tough
Delago
spot where
also
I'm
doesn't know
proving
who installed it.
negative.
Delago also doesn't know who installed it.
Right. Delago said the same thing. He didn't know who installed the tree well, but that the building did not get involved in installing tree wells, but that it could have been the city. But he didn't know who installed it.
But what we do have is the 2002 permit. And the 2002 permit dovetails perfectly with Mr. Strauss's testimony, and all this was presented in our motion in chief, to say that the permit, which fairly exonerates my clients,
Does it, counsel?
yes,
The fact that a permit exists doesn't mean that work was done.
well, I guess I
I mean,
have to
people
prove a negative.
people do pull permits, contractors do pull permits and not use them.
Okay, but here we know that there were tree wells installed. Again, I'm kind of at a loss of trying to prove a negative here where there's nothing tying my clients to this. And I actually have a permit for this location issued by the Department of Transportation, which is exactly what Mr. Strauss said would happen if the Parks Department was going to do tree wells.
So
Because
are you insinuating that, or implying, rather,
if a
that Parks, no, don't talk over
I'm
me.
sorry.
Thank you so much. Are you implying that Parks did the installation?
I'm saying that that permit certainly says that it was a Parks contractor using a Parks contract with a community board
Didn't
number.
that contractor also do public work? Wasn't the testimony that that contractor does private work and public work?
That he can do private work and public work. I don't think there's any dispute about that. But there's a Parks Department contract number on it. There's a community board as the also indicated on it. What's not indicated on that is 19 East or BHS.
Right.
They're not involved at all. And Mr. Strauss testified very clearly that if a private landowner was going to do this, there would have been a permit issued by the Parks Department. And there is no permit issued by the Parks Department. Only the Department of Transportation issued a
That
permit.
permit was for a stretch of 72nd Street, right?
72nd.
It's from, it
Madison
stretched from
Avenue.
Madison from 72nd to 73rd.
Correct.
Was a permit. Does it specifically state that it referenced that particular tree well? Meaning that's 2002. Could the tree well have been installed prior to that permit being issued?
Everything's possible, Your Honor.
No, but I'm just
But
wondering.
is there any
does
proof that we
con-
did it? No.
So would that conclusively state that, again, your client did not install the tree well?
Again, I'm
mean,
in a
I-
bit of a loss of trying to prove an
I
absolute
understand.
negative. What you're asking me to do, and what ultimately plaintiff's going to ask this court to do and the jury to do then, is, hey, could you all speculate that they did this? Because there's no proof of them doing it. The only permit doesn't name them at all. The people that they work for, they searched for records, and they got no records of them doing it. I have no record. I, the plaintiff, have no record of them doing it. The city normally installs them. The city maintains them. They're not part of the sidewalk that we're obligated to do, but please speculate and find 19 East and BHS.
Well, it was your motion for summary judgment, which was denied. The city's motion was also denied, right? So,
It was denied, yes.
okay. Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court, Susan Paulson on behalf of the city Appellees. Your Honors, the Supreme Court erred in denying the city's motion for summary judgment. The city established.
Why doesn't that permit issued by DOT sort of at least create an issue of fact of the city being involved in it? It's issued to a contractor who usually does jobs for the city, although not only jobs for the city, but who else could have been involved in light of that DOT permit?
Yes, Your Honor. Well, two responses. First of all, the testimony of the city witness was that that contractor did work for the city and did work for private individuals, and that the contractor could have been retained by a private, a budding landowner to install the tree wells. So that's who else the contractor could have done. But Your Honor.
Your colleague is saying that this permit somehow ties the city into it. If you could respond to that.
Yes, Your Honor, even if this, and I absolutely do not think that it's a fair inference from the record, given the testimony that the tree well was not the sort the city installed. It wasn't of the design, it wasn't installed in the manner of. The testimony was clear, but even if there could be a question of fact whether the city installed it, the cause and create exception is unavailable as a matter of law. If the city installed this tree well in 2002 that the plaintiff allegedly tripped on 15 years later, that wasn't even examined by her expert until 5 years after that, until 2022. The expert came, looked at the tree well, and opined that various defects of the soil level, of the ivy overgrowth, and of the placement of the tree guard versus the sidewalk flag, that the confluence of those defects.
So it would be your position that you're out because you had no notice?
There was no notice, and that's
That
not
you would-
disputed.
that you should be given summary judgment because you had no notice. Which is-
Correct.
But the permit issue does have significance to your co-defendant if it in fact established that the city did the tree well, installed the tree well.
It could have impact to the co-defendant, but the city's motion for summary judgment was improperly denied, where the city made a prima facie showing that it lacked prior written notice. The burden shifted to the
What I was
plaintiff.
hoping to hear from you is why this permit doesn't necessarily mean that this was done by the city.
The reason why the permit doesn't necessarily mean is the permit is a street opening permit from DOT. It's not a Parks Department permit for the installation of a tree well. As Your
What's
Honor.
the distinction between the two?
Yes, well, there has to be, if there's no tree well, first there's a street opening permit. That has to be issued regardless of whether or not a private or the city puts in the tree
Street
well.
opening permit means sidewalk and the street,
Yes,
or the street?
correct, Your Honor. And then for the installation of the tree guard, the Parks Department then issues a separate permit if it's being installed by a private landowner. If the Parks is installing it itself, there's no second permit issued. Here, we know there's a street opening permit, which arguably could create, speculatively, a question of fact as to whether or not there was, because of the destruction of records during Superstorm Sandy, there are no other permits, we don't know. But the Parks Department testimony in the record was that the design of the tree guard was not one the Parks Department used. The placement of the tree guard was not the manner in which the Parks Department installed them. And so it was speculation, first of all, speculation that the street opening permit resulted in the installation of the tree guard, and then that contractor installed it, that it might be the one that was in place 15 years later, the same one, and that it might be in the same condition that she then tripped on. And what we
You're saying
have,
that this DOT permit really tells us nothing as to who installed the tree guard.
yes, Your Honor, that's correct. Either way, there was going to be a street opening permit if a new tree guard was going to be installed. If it was then going to be installed by a private landowner, there would be a subsequent Parks Department permit. If it was going to be installed by the city, there wouldn't be that.
And the absence of permits may be as a result of the fact that records were destroyed.
It may be.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court. I believe that the motion.
Counsel, just make your appearance, please.
Oh, I'm sorry. Mitch Frankel from Sussman and Frankel on behalf of the respondent. I believe that the motion court's decision and order here should be affirmed, as there are issues of fact, as I think is evident by the discussion here.
Well, if the city had no notice, why should the city be in the case?
Well, I don't think this is an issue of notice. This is an issue of cause and create. We didn't argue in our paper.
From 15 years before?
15 years before, 20 years before? I mean, if they caused and created it, yeah.
But do they not still require or need notice in terms of any defect or any issues with the tree well?
Not if they installed it improperly. Now,
Well, if they created the condition, doesn't that condition have to create an immediate defect? Don't we have to have information that it was immediate?
It was immediately created at the time they improperly installed it. They put the tree guard in more than 5 inches from the edge of the sidewalk with a massive gap. Even the city's witness conceded that's a tripping hazard. He said, well, it's not.
What evidence do we have in the record that that was immediately created from when the permit was issued?
Well, this is not a transient type of condition. This is not like where they patch a sidewalk and due to the weather and wear and tear of people walking on it, it's going to perhaps change over time.
How do we know that? How do we know that? Could there be some type of erosion, something with the pavement? I mean, how do we know all these 15 years later?
Well, first off, it's anchored into the ground, all right? It's not.
When I asked about evidence, right, like what do we have in the record by way of any expert testimony or anything that says that this was something that was immediately created?
Well, you have it from my expert who examined and inspected the location. He says it, and yeah.
What did he say?
He said that it was improperly installed at the time, that it was improper at the time of installation. And
it's not about the improper installation. It's about whether that installation immediately created a defect.
Well, if they install it 5 inches away or 4 inches or 6 inches or 10 inches, it's still a substantial gap, and it's still more than the city's requirements are, and it's still more than what's commonly accepted, not only by my expert, by the city's own expert. And my expert found that there were other tree wells and tree guards that were installed on that particular block pursuant to that, likely pursuant to that permit. Now, again, we don't have certain records because of Superstorm Sandy, and they say, oh, they're retention policy. So do they get off scot-free because they don't have records?
Doesn't that lend itself to defendant East 72nd's argument that this is really pure speculation?
I don't
that
think
you're trying to prove they are put in a bad position of trying to prove a negative?
Not at all. The testimony is it's either the city in the majority of the cases or it's a private abutting landowner in the minority of the cases. Somebody installed it, okay? It's not some rogue person on the street just wandering around. So the evidence is it's either the city or it's the abutting landowner. And I think it's for a jury to decide which evidence that is before the court has more weight to it. Is it more likely going to be the landowner, or is it more likely to be the city? Now, the city, I'm sorry, the private landowner says, well, this shows that it's more likely the city. And they say, well, look at the community boards. They make recommendations, and they make recommendations to the Parks Department, who then may or may not actually install these tree well guards. It also has a reference to a city contractor. Now, a Parks contractor, excuse me, but that very well may be a Parks contract, but it might not be a Parks contract.
And therein lies the issue in terms of speculation. Thank you.
My understanding, page 27 of the record, the city admitted that's a Parks contract number. I'm going to speak briefly about the gap, right? Caused and created the gap. No.
I'm sorry,
Because
a Parks contract number, but no contract.
I'm sorry. I said the city said it was a Parks contract number, period. End of sentence.
But we have no copy of a contract.
But we don't have a copy of the contract. And certainly we don't have it because we're not the city, and we wouldn't be that. Council talks about the gap, okay? Let's remember that the plaintiff isn't here because she hit this grate. She doesn't say that she hit the grate. She just steps into the well. So the grate being there or not being there doesn't matter. A gap doesn't matter. It's not a proximate cause of the accident. Just putting that out there. And of course, cause and create, of course, erosion.
I thought plaintiff's expert talked about an excessive gap between the surrounding sidewalk and the tree guard.
He does talk about that. And what I'm saying is that plaintiff's testimony, she never hits this tree guard. The tree guard is kind of a red herring in this whole thing. What is really at play here is the level, the height difference between, which of course brings me to what I really want to talk to you about, is that it's open and obvious when you look at the photograph here, you can see, and we're all New Yorkers, we all walk around, who steps in a tree well? You don't do it because it's open and obvious that it's there, okay? And because it's open and obvious, it's not inherently dangerous here. It's not a 30-foot fall, okay? It's not something that you look at and you're going to get hurt, but it's obvious.
Open and obvious doesn't get you to summary judgment. It only excuses that there's no duty to warn.
Well, I think if I have no duty to, I have no duty at all to this person. I think the evidence demonstrates that. But, Your Honors, I thank you very much for your time.
Thank you. So
Your Honors,
what
as a-
about the plaintiff's expert who spoke about the fact that it would have been installed negligently from the beginning?
Sure, Your Honor. The plaintiff's expert opined that the tree guard that he examined in 2022, 20 years after the alleged installation, was improperly installed and defective. He provided no opinion or evidence that it was the same tree guard, that it was in the same position
Well, you said it was
as when.
anchored, right? So,
Pardon?
Your friend stated that the expert stated that it was anchored, which would suggest that it couldn't move or there was no movement.
Well, it would suggest that equipment would be required, but I don't know that that suggests that that tree guard could not have been replaced or modified or changed in any way in the course of 20 years. He looked at it in 2022, had no opinion as to whether
What
it was.
about counsel's statement that the city conceded that it's a park's job?
Yes, I don't believe that the record bears that out. In the record, I'm sorry, let me just find it. It's a street opening permit from DOT. And it's, here we go. It's in the record on 758. Your Honor, I see my red light is on, but in order for the city to be held liable, as Your Honor has recognized, under the cause and create exception to the prior written notice law, the defect has to immediately cause the hazardous condition. And here, the argument that the plaintiff is putting forth is that a tree guard that was installed 15 years before the accident, with no evidence that it's the same tree guard or in the same condition, immediately caused a hazardous condition. There's only speculation in the record that would support that argument. The evidence that the plaintiff relies on in support is her expert's testimony, and her expert examined the tree guard and the site 20 years after installation in 2022.
Thank you. Thank you all.
Thank you very much, Your Honors.
STA Parking v. Federal Insurance. Yes.
May it please the court. Good afternoon, Your Honors. Catherine Peluso from Venable on behalf of STA Parking Corp., plaintiff appellant and respondent on the cross appeal filed by Federal Insurance. This is not the first time that this case has come before the panel. In 2022, Justice Gonzalez and Justice Weber sat on the panel that unanimously affirmed the trial court's decision that Federal is liable for coverage of the underlying judgment under its first excess policy. That decision, citation is 209 AD 3rd 510 of 2022, and can also be found at record site 2614. And that decision is law of the case. Federal monitored this case, attended mediations and settlement negotiations since 2007, and never once raised a fraud or collusion argument in more than 10 years.
Well, did they have those emails back then?
Your Honor, they did have a majority of the emails back then, and in fact, Mr. Wolfson was keeping Ms. Wang, the monitoring counsel from 2007 for a period of 7 years, fully informed during all of the settlement negotiations. She was asked to comment and provide input on those negotiations.
You're
and did
basically
not.
saying that federal knew that your client was working with the other entity, the building owners, to get more insurance coverage?
Federal was fully aware that Mr. Wolfson was working to work out a settlement with the E77 owners to, yes, to get more insurance coverage. That's correct.
You say that our prior decision is law of the case, but that wasn't what we decided in that prior case. We only decided there that the underlying liability arose out of events that occurred during the policy period. We did not deal with the issues which are being presented to us now, that there was some sort of collusion, I guess they call it, going on to get federal to have to pay where they otherwise might not have to pay. We didn't address those issues in that decision.
Well, Your Honor, actually, in the 2022 briefs that Ms. Brill filed and argued on that motion, she did raise some collusion and fraud issues, never argued them, and the court never addressed them.
Right, so there's no law of the case regarding that issue.
Well, Your Honor, that's correct. There's law of the case regarding federal's liability to cover the underlying judgment. And furthermore, what we're
The
here...
events occurred during that policy period. That's all we held in the prior decision.
Correct, Your Honor. And on STA's motion for summary judgment, our only claim against federal is breach of contract. And with respect to that claim, STA has met its burden in demonstrating that federal breached the policy by declining to provide coverage to STA. The burden then shifted to federal to raise material issues of fact to preclude summary judgment.
Counsel, I have never seen a maze, I'm going to use the word maze, of facts, of alleged facts, of emails. Apparently, according to what federal is saying, everything was aimed towards triggering their excess policy. And in order to do that, there were all kinds of agreements to receive monies, redirect monies, make payouts, not really make payouts. I don't see how this is anything other than a huge mess for a jury to decide.
Your Honor, I'm glad you raised that problem that we're all grappling with a 3,000-page record created by none other than federal's counsel.
Well, let's just talk about this. What loss did STA incur here?
Well, STA's building was also damaged by its...
No, what payments have been made by STA?
STA procured settlements from several of the wrongdoers, the contractors in this case, and then was forced to turn those over.
You procure settlements for other parties for East 77th Street, and instead of those checks going to East 77th Street, you have the checks made out to STA, and STA then endorses those checks over to East 77th Street. How is that STA's loss?
Your Honor, because STA was entitled, those were on STA's counterclaims against those contractors for causing the damage at the property.
Those were for losses to East 77. That's what those payments were made with respect to.
That's not only what those payments were made with respect to. Those payments were made to cover STA's damages incurred on the damage at the property, and furthermore, a portion of that was CBS.
If the money is supposed to end up at East 77th Street, why do you have the checks get made out to STA?
Well, Your Honor, I'll argue this by analogy. If I owed you $10,000 and you owed Justice Weber $10,000, if I pay it directly, that wipes out your debt to Justice Weber. That is STA paying out of its pocket money that
But that's
it
a
was
little
usually-
different. That's different because in your scenario, one judge has received money, right, that they were supposed to pay back. So they've suffered a loss because the one entity received actual money and then they didn't pay it back, and then you instead paid it back. There's no loss here. STA had not paid out any money. You took money, right, so that it could appear that you were making payments when you weren't actually making payments. You had gotten money from another entity, but had never previously made any payments. That's very different.
If I may just address, I see my time is up.
Just if I can add to Judge Michael's question and your analogy, here the loss was East 77th Street's loss. It wasn't STA's loss.
No, and then we, if I may, I'm referring to record page 723 and 722, but particularly 723, where Mr. Wolfson says, looks like all settlement funds will flow through me for insurance purposes to get access to the Chubb policy, Chubb being federal, of course. I mean, what was going on here?
But the bottom line is, again, how did STA suffer a loss? That's what we're not understanding.
STA did suffer a loss. It recovered $310,000 from its CBS insurance broker on a malpractice claim. That was a portion of the money that was used to be put towards the $1.4 million that went to E77 in the settlement. Furthermore, the amounts collected from the subcontractor or contractors, the wrongdoers, that STA was entitled to collect because of damages to its property and all of the legal costs it had incurred, was turned over to federal.
Thank you.
Good afternoon, Your Honors. Melissa Brill from Cozen O'Connor for defendant, respondent, and cross-appellant Federal Insurance Company, which I will also refer to as Chubb. This is no ordinary coverage case, as it appears that Your Honors understand. It's clear that you're very familiar with the facts.
If STA had any loss vis-a-vis East 77th Street, once East 77th Street got paid, STA wouldn't have that loss anymore.
That's correct, Your Honor, and not just
So that does not provide a justification for funneling these checks to STA to endorse over to East 77th Street.
That's correct. And just to add an additional fact to that point, STA was not even released as part of that settlement agreement. That money had no benefit to STA. They were purely, it was a straw payment scheme, as we're referring to it, to pass it through to get at Chubb. I believe it sounds as if Your Honors agree that summary judgment cannot be granted in this case for STA, and unless you have questions for me on that topic, I'd like to address the one issue that we believe the court erred on in its order, and that is denying Chubb's leave to amend its counterclaim to add the fraud claim as barred by the statute of limitations. That claim is timely, and the reason it is timely is because a fraud claim has a 6-year statute of limitations with a 2-year discovery rule from the time that someone reasonably should have discovered the fraud. And as Your Honors understand, the fraud here is complicated. We, meaning Chubb, did not get the documents evidencing this fraud, the emails back and forth between STA's counsel and E77's counsel, until approximately March of 2022. That is when we had, or that was, by the way, 50,000 pages of documents in one document dump that we had to review to find the particulars required to plead this fraud claim. What about the settlement that you received in 2015?
Yes, well, I didn't, but monitoring counsel, I believe, or prior coverage counsel did receive the assignment agreement, which gave 40% of recoveries against itself to STA and its counsel. And that should raise, I would think, an alarm. But what happened at that time was that STA's counsel indicated that he was ready to enter into a consent judgment for an agreed amount of money. Counsel for Chubb opposed that, objected to that, and as a result,
counsel for STA agreed to have an inquest hearing as to the damages against STA. The implication of that was that that was going to be an adversarial proceeding where STA actually defended itself against the damages, but that's not what happened at all. In fact, the STA's counsel made no objections and no opposition to the damages presented by E77, and the inquest judge himself had to reduce that judgment by, I think it was about 50%.
You're also a cross appellant here, seeking to restore your fraud cause of action.
Yes.
How do you get past the statute of limitations problem? Because certainly by 2015, if not earlier, Ms. Goodman was aware of facts which should have put Chubb on inquiry notice that there's something amiss here.
Yes, and that is exactly what I was addressing, Your Honor. She did receive that assignment agreement, but I will note that the inquest court did not. So that inquest court awarded the damages against STA that they are trying to collect here without knowing that STA was going to get 40% of that money themselves. And Ms. Goodman did object to the consent judgment being entered.
But the question is whether you're within the statute of limitations on fraud. How are you within the statute of limitations on fraud?
Well, that's assuming it was fraud, because I'm not really sure that that's what you were claiming. I'm not really sure that that's a fraud claim or something else.
Your first counterclaim is to restore a cause of action for fraud, correct?
Correct. We have several counterclaims, one of which is fraud.
Right, but the first one is on fraud. So how does that fraud counterclaim get past the statute of limitations issue?
Because, Your Honor, we did not receive the emails which are addressed in detail in our brief until March of 2022. That is when we had the particulars of the fraud, and we pled them within the 2-year discovery.
You don't need the particulars of the fraud to put you on notice to make inquiry, and that you knew by 2015.
And had we had that agreement, or because we had that agreement in 2015, we would not have had enough information to plead with particularity this fraud claim that we are now.
But the question is not whether you had enough at the time, but whether you had enough to make additional inquiries.
I think the inquiry was, why are you agreeing to these damages? Why are you consenting to this judgment against you? And then counsel agreed to have an inquest where he would adversarially challenge these damages, and then went to the hearing and did not do so.
Right, and when that did not happen, weren't you on inquiry notice at that time that something was amiss, as you said?
Yes, I believe so. And
so that's when the statute of limitation begins to run on a fraud claim, no?
But there would be no way for us to have gotten the information that we have until discovery, and once we got that information, we pled within 2 years.
Thank you.
Thank you, Your Honor.
Your Honor, to first address the fraud allegations, they did have everything they needed, and Ms. Goodman was actually provided access to Mr. Wolfson's office to go through all of his records. She reached out to Mr. Wolfson numerous times asking for additional records, which she was provided. Furthermore, to address Ms. Brill's comments on the assignment agreement, if you look at record 258, which is section 3, specifically 3.2 to 3.5, Federal was given permission under this assignment agreement to intervene in the inquest itself. And just as Ms. Brill said, it was a judicial inquest. Never at any point did STA consent to any judgment, agree to any judgment, admit liability. That did not happen anywhere in this record. And I know my time is limited, but there is one other thing I want to address that goes to the fundamentals of both of these motions. Federal has never once submitted any affidavits of people with personal knowledge. They have never sought to take deposition testimony.
Personal knowledge of what? Of the collusion?
Personal knowledge of any of the underlying facts.
Well, the emails tell us all we need to know, don't they?
No, they do not, Your Honor. Those emails are a patchwork of lies woven together by Federal.
Wait.
That is what's done here.
Attorneys who wrote the emails were lying?
No, Your Honor. What I'm saying is this is a patchwork done by federal to make it seem like there's something amiss here when really there's not.
Are you saying that there are additional emails or additional information, documentary information?
No, Your Honor. What I'm saying is that federal has conveniently taken sound bites from certain emails, put them as if they happened with other emails, and you can see that. It's abundantly clear from the record that there's pieces of emails missing. They conveniently
Well, I
submit.
asked you, are there pieces of emails missing?
Yes, Your Honor. I would submit to this court there are pieces of emails missing.
What's missing from an email that says, flow all of the settlement payments to me so that we can get at the Chubb policy? What are we missing with regard to that?
Your Honor, what you're missing with regard to that is that that was done with the money that STA received for its own losses. Checks were made out to STA, and then those checks were endorsed over to federal. There is nothing amiss or collusion related about that.
Those checks were not for STA. Those checks were in relation to settlement with East 77 that then were made to STA according to the email to be able to get at the Chubb insurance policy.
They were checks that STA was entitled to on its counterclaims and also the CBS settlement that occurred for malpractice.
Counsel, I don't know if the documentary evidence in the record, I don't know if that supports your argument.
I submit to this court that it does, Your Honor.
Thank you.
Thank you.
Excuse me, counsel, it's just time of rebuttal.
Unless Your Honors have any questions for me, I'll rest.
Thank you.
Thank you.
Southgate Owners v. Esposito. Yes.
Good afternoon, Your Honors. May it please the court. Jeremy Cohen of Braun, Hagee, and Borden for Southgate Owners Corp. There are several reasons why dismissal was wrong and should be reversed. The first of those is a threshold issue. Esposito brought a motion to dismiss based on the statute of limitations under CPLR 3211A5. Under 3211E, a motion of that nature has to be brought pre-answer. They brought it post-answer. This court has addressed that numerous times, most recently Smith, Gambrill, and Hahn. Some members of this panel were on those panels, and so that rule is as straightforward as it sounds. So for that reason alone, at the threshold, there should be a reversal. But beyond that, the court below misunderstood and misapplied the statute of limitations. The key issue in this case is that Southgate allocated additional co-op shares to Ms. Esposito in April of 2024.
After you filed your action.
It was essentially contemporaneous. It was the next business day, but it was essentially contemporaneous.
For alterations that occurred in 1995?
That's correct. There's no question, 96, 97 actually, but
Are there share certificates in the record?
they are not. No, because the issue percolated, we notified Ms. Esposito that the shares were being allocated, and then this litigation came about. So there has to, we still have to, part of the.
So there are no share certificates right now?
Correct. That's part of what we'll have to do.
How can shares have been allocated per your own?
We notified her of the allocation. We notified her that shares are being allocated, charged her account, and so, and then this litigation ensued.
How can you request, how can you seek payment of what past due maintenance fees when the proprietary lease at paragraph 1A says that maintenance is paid prospectively from the date of issuance of shares?
So the shares were issued non-pro-tonque, and I understand that.
Wait, what did you say?
They were issued retroactively.
How? With what authority?
So it was under the authority of the governing documents, which say.
What part of the governing documents? Counsel, you know what an offering plan is. I know what it is. You know what a proprietary lease. I know what it is. We all know what those documents are together.
Right.
So what part of the proprietary lease contradicts what I just read to you?
So what we're relying on, Your Honor, is the bylaws at Article 5, Section 3, which makes the allocations mandatory. They're not bounded in time. I understand the concern.
The bylaws at 3 says the board shall adopt the allocation of shares set forth in the plan. Where's the stock certificate? You just said that there is none. There's no, where's the certificate?
There will be an
Counsel?
updated,
No. You talking, you can't talk out of both sides of your mouth, right? So if you have a proprietary lease that says that payment goes prospectively from the issuance of the shares, and you are telling us, oh, we haven't done that yet, then why are you here?
because, Your Honor, well, I think that issue goes to the remedy, not the right to allocate, and that's one of our alternative.
You haven't exercised it fully. You haven't executed the deed because there's no allocation.
If that's the case, if that's the case, then there's no statute of limitations issue at all. We'll still have to take.
No, we still have that problem. We definitely have that problem. You're seeking maintenance from 1995 for the alterations that were done in that period, right? 95, 96, 97.
97, 96, 97. So, yeah, so if there is a statute of limitations issue, as Your Honor is indicating, all that would mean, it wouldn't nullify an allocation made as of April 24.
Why do we even have to get to a statute of limitations issue? Because as Justice Gonzalez read to you from paragraph 1E of the proprietary lease, it says from and after the date of issuance. How could you possibly be entitled to collect anything before the date of issuance? Without, we don't need to consider the statute of limitations issue, because only when the shares are issued could you begin to think that you're allowed to collect maintenance for it.
So that's part of our alternative argument, that at a minimum, from April of 24 forward, we're entitled to allocate and charge. So we have made that argument as an.
Well, have you actually issued new shares?
We notified her that shares were being issued and that.
But it hasn't actually been
sorry.
done.
You know what? I have to agree with my colleague. You're talking out of so many different sides of your mouth. It is unbelievable. It's so confusing. There are no shares that have been issued. You intend to issue the shares. You notified her that you were going to issue the shares, but the shares had not been issued. Your alternative argument is, although we didn't issue the shares in 1996, we still weren't. What has been done thus far?
So we notified Ms. Esposito that shares were being allocated.
When did you notify?
April 24.
April 2024.
Correct.
Okay, and
shares were being allocated.
They were being allocated.
We were charging her account, and the charge was imposed on her account.
And again, what allows you to do this? To notify her of this?
The provisions of the proprietary lease and the.
How much did you tell her the shares, the allocation was for? What was the amount?
The number of shares, or the
amount of money she owed?
The amount of money was a principal of $300,000 plus interest, which
equals $1 million.
About $1 million.
$1 million. So all of a sudden, she owes $1 million for shares that she hasn't received.
But she will be receiving.
But for shares
someday.
But for shares that she was fully aware were to be
Counsel,
designated.
there's documents. There's a reason why there's a proprietary lease. There's a reason why there's an offering plan. There's a reason why there's bylaws. Those are the governing documents. You are talking all over the place.
So in April 2024, you notified her that as a result of the allocation effective January 1, 1996, she owed $311,000, right?
Correct.
Plus interest.
Plus interest.
On shares that you hadn't allocated, but okay.
But will be
But just to be clear, the shares are yet to be issued.
Look, the reason that the share certificate wasn't.
Have they been issued?
Was because.
That was a yes or no question.
No, the reason being because of this dispute.
Because but.
Well, yeah, but yes, but you're ready to issue the shares, right?
And that would mean the statute of limitations hasn't begun to run, which is a separate question.
Okay, I'm sorry. I caused you to confuse the issue even more. I apologize. You have time on rebuttal.
Good afternoon, Your Honors. May it please the court, Bruce Wiener for respondent Phyllis Esposito.
If they had issued, let's say tomorrow.
There are no shares.
You have no shares, but if tomorrow they issued shares, you would agree that starting tomorrow they could impose charges for those shares?
No, I would not agree to that. In fact, below, they claim they could have waited 50 years and retroactively issued
Not
the shares back to
retroactively,
1996.
not
prospective.
Not retroactively. If tomorrow they issued shares, going forward, not anything for the past, but going forward, would they be allowed to charge you maintenance for those shares on a going-forward basis?
No, they would not, because they have no remedy anymore. The court below said that this cause of action accrued at the latest in 2014.
Well, the cause of action relating back to when the space was initially renovated, but I guess what we're asking you about is now that she has access to that space, can they issue shares based on what she has access to presently today, the increased space?
That space was always part of her apartment. It was on the terrace. It was enclosed. It's not additional space. It's space that she enclosed. And in fact, in the record, it says that the board at the time decided not to issue additional shares, contrary to the letter they had originally sent, because she gave a benefit at her own expense to the co-op by.
Well, we don't have anything in the record establishing that that was what the board decided, right?
Well, the parties charted a summary judgment course. This argument about an untimely motion to dismiss was never made below, and it's in fact totally false, because what it means is we moved post-answer. We had put in statute of limitations defense in the answer. Post-answer, we moved on a 3211 ground of statute of limitations and summary judgment on our attorney's fees claim. They cross-moved for summary judgment, but they didn't put in any proof, and they didn't refute any of the allegations that were made and the proof that we submitted. So we charted a summary judgment course. They can't come to this court now and say, well, it was a motion to dismiss and it should have been converted. They moved for summary judgment. The court below was empowered under 3212 to grant summary judgment to any party, even if we hadn't moved. The court could have done that based on the pleadings.
Counsel, I want to ask you a question based on the C of O and the amended C of O.
Yes.
So is the allocation of space, the square footage, changed by virtue of the enclosure of the outside terrace?
In 1997, there was a new C of O issued that showed that some portion of the exterior space became interior space, but it was always her apartment. It was not additional space that was given to her.
Right, but it wasn't usable as it was when she initially.
It was a terrace. It was definitely usable.
Right, but without it being enclosed.
Right, does the square footage change? Because
the square footage, the
interior versus
square footage changed.
Huh?
The interior square footage changed.
Right.
And that was in 1997 when the C of O was issued. They purported to retroactively.
But the board had to approve that enclosure, didn't it?
It definitely did.
Yeah.
They did.
Yeah.
It totally approved it, and then decided not to issue shares.
So are you arguing that should not be an additional allocation of shares?
There can't be now an additional allocation because they basically waived it, even though they claim that there's a no waiver clause in the lease. This court, as recently as last December, said a no waiver clause can be waived. Here, they were on notice. They came begging to her. We know it's time barred. That was,
Right, and she refused to.
And she
accept
said,
that.
no, I gave you this benefit. I paid for an interior staircase for the co-op's use rather than do it in my apartment.
So there was consideration for the waiver?
Much more than consideration. This was the president of the board who came to her and said, please do this so our workers don't have to climb gangways when they have to do service things on the roof. Build this interior stairway. It was built in the co-op space, not in her apartment, which she could have. It's a duplex apartment. She could have put in an interior staircase at a much cheaper cost. She put in an exterior staircase for the co-op's benefit, and they decided not to issue shares. And then they came to her in 2012, the president came to her. In 2015, the board's counsel came to her.
That hasn't been rebutted, right?
Never rebutted, and no share certificate ever issued,
Well, we know
even till
because
today.
She refused to accept the additional shares.
Right, but even though the proprietary perspective from the time that the share certificate is issued, they never issued a share certificate to her.
What would happen if she sold the apartment? Could the board come to the new buyer and say, You get more shares for this apartment?
Right, that this apartment is 400 and some odd shares as opposed to 2 something?
Not based upon the decision in the litigation. A purchaser, but they claimed below that they told the judge that they could have waited 50 years. So the apartment could have been sold many times, and they could have then allocated shares to somebody who was a total stranger by that point. That was their position.
Thank you.
Thank you.
In fact, Your Honors, that
Counsel, you keep saying that the shares were allocated or she was on notice that they were going to be allocated, but doesn't the co-op have a separate lawsuit against a board member for failure to allocate those shares?
it does.
So you've admitted that the shares have not been allocated.
I haven't disputed that.
Okay, I'm
we
sorry.
allocated.
I thought
We
you
sent a notice of allocation in '24. She disputed, and that's why we're here. I do want to address the idea that we didn't rebut their facts. That's kind of the whole issue with whether this was a motion to dismiss or summary judgment. They moved to dismiss, not summary judgment. They did not put forward a summary judgment record. They didn't comply with Rule 202.8G, which was then in effect. We didn't. Certainly the court below didn't say, I'm converting this to summary judgment. So we never.
Did have to?
He did have to. And the record they put forward was essentially a nothing. It was her statements.
Did you counter with a motion for summary judgment?
But it was on a separate set of issues, and we cite the DeAngelis case out of the third department, but where you cross-move for summary judgment against a motion to dismiss.
The court just say, summary judgment from you, I can do summary judgment from them?
Look, it could, but that's not what the court did. And there's no record, there's no summary judgment record in their favor. All they have is her.
But you cross-moved for summary judgment.
Right, but that didn't convert their motion, and the judge below couldn't convert without giving us notice. We would have certainly taken the opportunity to rebut. In fact, we specifically said in our opposition that because they didn't make a summary judgment record, because they didn't comply with Rule 202.8G, then in effect, that we were not addressing certain of their facts, all of which were basically her say-so about things that happened years ago and putting words in the mouths of people who have been long
Did you
deceased.
controvert any of that?
We didn't have an obligation to because it was a motion to dismiss. The court was obligated to credit our allegations. It should not have considered her affirmations.
The answer is no, you didn't rebut it.
Because they're outside the four corners of the complaint on a motion to dismiss. The last thing I need to mention, if you could just indulge me for 30 seconds, is the issue of attorney's fees. They moved for attorney's fees on the basis of a default under the proprietary lease or RPL 234. That's the only basis there could be for fee shifting here. The court did not find a default. All it did was find that that our complaint was untimely when it dismissed. So there's nothing in the proprietary lease and nothing in RPL 234 that warrants fee shifting.
But wasn't there actually a finding that, so she sought to enforce her purported obligations under the proprietary lease, and the court said yes. I mean, she prevailed on that, so why would that not entitle her to?
No, she didn't. There was no finding of default. She moved to dismiss on statute of
I
limitations.
didn't say default, I said defendant prevailed in her defense,
Yeah.
seeking to enforce her obligations under the proprietary lease.
No, but the court moved, the court dismissed on limitations grounds. The court did not find a default by Southgate. There's no claim of default by Southgate here.
But didn't she actually prevail?
But it's not a prevailing party provision. RPL is only if there's a default under proprietary lease. RPL 234 equalizes the playing field for tenants and landlords only when there's a default under the proprietary lease. The court below.
You're saying
were
if
you claiming there was a default because she
No.
didn't pay but you wanted her to pay $1 million
We were allocating
back
shares.
maintenance,
You didn't
right? Didn't you send her a notice?
But it
You owe $1
wasn't-
million. This is $300,000 plus interest.
But it wasn't
And
a
she
notice.
came in. That would have been a default, right? That would have been, you were alleging that she was in default. And so you took the opportunity to do that, right? You didn't wait till you had the shares issue. You took the opportunity to have that litigation tactic, and then she came forward and said she didn't owe it.
But we didn't.
And therefore, she prevailed on this
Prevailed on that
default
because,
action.
exactly, because now she prevailed in that she doesn't have to pay. The court ruled that she didn't have to pay the $311,000 plus interest.
Right, but we didn't assert a default. We were looking for a declaration of our right to enforce the allocation. If we lose on that, then we can't go after her, we can't collect, no question. But if we get a ruling that says we can, and then she doesn't pay, that's a default. But what we're doing is not alleging a default. We didn't say she defaulted. We sought a declaration of our rights to.
So nowhere in your complaint did you say that she defaulted in payments on the,
Will not find that word, no.
Oh, okay.
Thank you.
We did
Did you
not.
make much of the fact that this plaintiff, the defendant's motion was a pleading motion, but defendant did move for summary judgment on a counterclaim for attorney's fees, did she not?
She did, but that doesn't turn her motion on statute of limitations grounds into a summary judgment motion. She very specifically moved for summary judgment on the fees, but not on the statute of limitations, which was 3211A5.
Thank you.
Thank you.
Graham v. the City of New York. Yes, Mr. Graham, whenever you're ready.
Good afternoon, Your Honor. My name is Kenton Graham. May it please the court, I'm sorry. My name is Kenton Graham, and I'm here challenging my termination from the New York City Department of Education, and also the decision made by Judge Moore. I believe that my termination was post-probationary and therefore defective. That is my argument. And I was hired on September 17, 2018 to serve a 4-year probationary period. That period completed on September 6th, 2022. The New York City Department of Education moved to terminate on September 7th, 2022. That is 1 day after probation ended. Therefore, I'm saying that this termination is void, and I should be placed back into my position as a teacher. The critical point here is that once probationary ended, Your Honor, I am entitled to due process, and that should have been afforded to me on September 7th. That did not happen. And here's the timeline, Your Honor. The Department of Education own verified employment record stated that on September 7th, I was tenured. The record also stated that I completed probation.
I thought they sent you something stating that you had not successfully completed probation.
No, ma'am. No, Your
Honor. July 29, 2022, you received a denial of completion of probation letter that terminated your employment as of close of business 60 days from the date of the letter or the probation completion date listed above, September 7, 2022, whichever occurs first.
Yes. Yeah. So that letter listed, the superintendent actually made termination on September 7th. Now, termination should have happened on somewhere around September 6th, if it was going to be legal.
So your calculation is that it should have been September 6th and not September 7th?
That is correct, ma'am.
And that's based on what?
Because 4 years from September 7, 2018, inclusive of September 7, 2018, it ended on September 6, 2022, and their own record conferred tenure on September 7th, that date.
But the letter said 60 days from the date of.
Right.
60 days from the date of the letter, so 60 days from July 29, 2022, or the probation completion date of September 7, 2022,
right,
whichever occurs first.
Right. So that that is my anniversary date, that's when tenure is granted. So that what the superintendent did there, they actually make termination effective on September 7th. If we look on the record 34, you could see that termination did happen on the tenure date, which is contradiction, which is contradictory to what has happened, because they're saying that I was tenured on September 7th and they also terminated on that same day. That cannot happen. If we look at record 34 there, we see that's what actually happened. I completed a full year probationary period.
Did you go in on September 7th or September 8th, whatever the days? I don't know whether it was a weekday or a weekend, but did you go in on September 7th or September 8th or September 6th?
September 6th, I did not report there because I was under the idea that I was released, but that wasn't the case. It was on September 6th because when I called the DOE, they said that.
Did you go in on September 6th or September 7th or September 8th? Did you go in at all?
No, I did not. I'm show up there on September 6th because the DOE, when I called the DOE, because Principal Johnson was, I asked to be released so I could have seek other employment. So I was under the impression that I wasn't still hired there, but that wasn't the case. When I called on September 6th, the DOE was saying I should have showed up there. And that time it was too late.
So someone told you that you should have shown up on September 6th?
Right, because I did call the DOE that
Is that
morning.
in the record in terms of who you spoke to?
No, I called HR. They could check.
And is there anything in the record as to whom you spoke to on September 6th saying that you should report to work?
No.
You have time on rebuttal. Thank you. Yes, counsel.
Good afternoon, Your Honors. May it please the Court. Jonathan Popolo for respondents. There are several reasons why Supreme Court's decision dismissing the petition should
So
be
did the
affirmed.
probationary period end? When did the probationary period end? Is it September 7th, September 6th?
September 7th is our position. It's not necessarily, it's not, we lay out why, because that's the anniversary date of his hire. But I think to a certain extent, this is a somewhat misleading issue that the court doesn't need to grapple with, because regardless of whether it's September 6th or September 7th, Supreme Court properly held that this proceeding was time barred, because whether you take either day, it was not instituted till nearly 2 months after the 4-month statute of limitation period had run. The 4-month statute of limitation period runs under well-settled law from the last day at work. So whether that's September 6th or September 7th, 2022, the petition was not filed until well into March 2023, about 6 months later. So it's time barred.
March 2023.
Correct, Your
And it
Honor.
should have been
The deadline would either have been January 6th or January 7th, depending on which date you want to use. So you don't really need to determine. Again, our position is definitely that it was September 7th, not September 6th, but that's not something that should have any bearing on the disposition of the case. Second thing is, even leaving the statute of limitations aside, and you don't need to go any further to affirm, but even leaving that aside, the rule for obtaining tenure by estoppel is pretty clearly established. You have to have a situation where the school board does not take any action during the probation period to either deny or grant tenure, and then knowingly allows the teacher to continue to work after the end of the probation period. Neither of those things happened here.
Well, I mean, he states that he telephoned HR and they told him that he should have come in on September 6th.
It's not alleged in the petition, but even you have to satisfy both elements. And the first element was not satisfied because they definitely did take action prior to the expiration of the probationary period to deny him tenure. There's the July 29th letter from Superintendent Ross, which is, I believe it's page 34 in the record, that clearly apprised him that we are discontinuing, we're not going to give you completion of probation, we're not going to give you tenure, we're discontinuing your employment. And
Explain the errors in the certificate of employment that petitioner
The
had that
verification-
said that he had tenure on September 7th.
Yeah, the verification of employment that was dated February 9, 2023.
don't have a definitive answer, unfortunately, Your Honor.
I'm sorry?
We don't have a definitive answer, unfortunately, Your
But
Honor.
do we
other-
know why that's, so February 9, 2023, there's a verification of employment that stated that he had tenure. He received tenure on September 7, 2022, and had completed the probation. So,
The record is silent as to that. I mean, my understanding is that it was some sort of system error. I unfortunately don't have more information than that. But I think what's sort of most relevant here is that there's you have a very clear indication from Superintendent Ross. They send this letter that says we are not granting you tenure. And then after, 5 months after his last day, I imagine probably in connection with looking for other employment, seeks employment verification and gets this form. But at that point, the statute of limitations is already run. So
yes,
even
however, he gets the letter in February, which now apparently alerts him to the fact that his employment was not terminated and that he does have tenure.
no,
And then he files in March. He files the next month, March 2023.
it's not accurate to say that it says that his employment was not terminated. It actually very specifically says his employment was terminated on the 7th. On page 30,
Says involuntary.
it says involuntary, and it says termination date 9/7/22. So that's the operative date for the statute of limitations. So even if, so this letter in February is irrelevant, and he can't argue that, I think there's an attempt in the brief to make an equitable estoppel argument, but that requires some sort of affirmative misrepresentation or affirmative action other than the alleged wrongdoing that forms the basis of the claim that prevented you from timely commencing the action. This letter in February could not have prevented him from timely commencing the action because it was received after the statute of limitations had already run.
So, counsel, the verification of employment says that the request was made concerning a verification of service history. So verification of employment here is a service history as opposed to saying you are currently employed. Is that what you're saying?
To a certain extent. I mean, I think if you look on the page, it says 31 in the record that says service history, it does say that his position as a teacher ended on the 6th of September 2022, and that on 9/7/22, September 7/22, his position status is listed as probationary discontinuance.
Yes, but to the extent that it also says tenure, do we accept that as saying that he now has tenure within the Department of Education?
No, we do not.
So how come we're supposed to accept part of what this document says and not the another part?
I'm not asking you to accept this standing alone. I'm saying you have a letter from the superintendent denying him tenure. You have nothing else. You have
Well,
no, you have a letter stating that his probation, that the probationary period, that probation was terminated, but then he gets a letter saying he has tenure.
But tenure doesn't vest automatically on the anniversary date. I mean, this is laid out in our brief. You have to have.
No, it doesn't vest. Nobody's saying that. We're going by the document. The document says you have tenure. Why is that not a true statement if it's coming from the Department of Education?
Because.
You made a mistake?
Yes.
So did they rescind this? Did they send a follow-up letter saying, oh, no, we made a mistake, it's not true?
There's
Actually,
nothing
you don't have
in the
tenure.
record. It's my understanding.
You have to
sorry, Your
listen
Honor.
to my question.
Okay, I'm sorry. Go ahead.
Thank you. Okay. Did they send a letter rescinding this?
Not to my knowledge, no.
So doesn't this stand then that he has tenure?
I don't believe so for the reasons I've just explained, but it also doesn't affect the statute of limitations argument. I mean, even if you have, the argument would be then that he had tenure, so he should have gotten a hearing.
Going forward, the plaintiff has a new job within the system, right?
I believe that's the case.
Okay, so if he has a new
In
job.
a different line, in a different,
If he has a new job within the system, doesn't that tenure carry
it does not.
certain
because-
benefits?
No, it doesn't, because I believe the new job is in a different line, a different field. So you have to do a new probationary period in a new field.
Thank you. Yes, anything further, Mr. Graham?
And if I'm hearing what the council here is saying correctly, that the statute of limitations should apply here. Should apply. But, you know, I was under the impression that they terminate me as a probationary employee. When I sent for my record, then it's saying something else. Then I brought my suit within the
So
required
did you
time.
submit any documentation or any affidavits or anything stating that you were unaware of the fact that you were terminated as of September 7, 2022, and that anything to that, as you're not realizing that you had been terminated?
No, I was under the impression that on September 7th, that date was I was still probationary there.
Thank you.
So when I found out thereafter that the 4-year, I was supposed to serve 1,460 days, and September 7th would be the 1,461st day, then there is a contradiction there.
Thank you.
Thank you.
Enriquez v. City of New York.
May it please the court, Avram Turkel for the appellant. Supreme Court dismissed this action, 3211, solely on the basis of Article 78 and timeliness. Respondents now concede that that was an error. The appellant is entitled, is in fact required, to bring an action on the New York City human rights law in a plenary action, not on Article 78. So this court should reverse and remit on that basis alone. Because the motion court never reached the New York City human rights law merits, you should also reverse and remit for a merits determination by the Supreme Court, especially where the respondent's alternative grounds depends on fact-intensive essential functions and reasonable accommodation and inference issues, an essential functions and reasonable accommodation analysis. So if you don't simply reverse, we ask you to reverse and remit for that determination. Whether the plaintiff could perform essential functions with reasonable accommodation is typically a fact-bound analysis. Respondents argue that appellant is not qualified, but the plaintiff alleges she performed the essential functions of her restricted duty assignments for years. In fact, for 3 years, the appellant performed the essential functions of her job with accommodation. And the notice pleadings.
Is there anything in the record that says that sergeants can't perform the desk duty assignments that the plaintiff held?
Is there anything in the record? No, but there is a pleading that in fact she did, right? That the NYPD allowed her to have her job as a sergeant with accommodation, and for 3 years, she did perform those functions.
But is there a bar? Is there a bar saying only police officers, not sergeants, not lieutenants, not captains, can do this kind of job?
There may be, there may not be, but on a 30.
It's not in the record, right?
No, Your Honor. And at 3211, the job description that respondents put in the record regarding requirements of a sergeant is not a fact inquiry, right? An inquiry looks at the employer's real operational requirements, the actual position, the available accommodations. All of that was pled by the appellant in her complaint. It was denied, it was dismissed on the basis of Article 78. That was incorrect. It was plenary action, properly pled. That should be sent back to Supreme Court.
Thank you.
Thank you, Your Honor.
May it please the court, Hannah St. Marie on behalf of respondents. This court should affirm on the alternate grounds that the complaint fails to state a claim and that amendment would be futile. First, the complaint fails to state a claim of disability discrimination for two reasons, each of which is independently fatal. First, it shows, in her own allegations, show that she was no longer qualified to be an NYPD sergeant, which is
How is she no longer qualified to be a NYPD sergeant?
Yes, Your Honor. She has multiple disabilities that prevent her from performing many of the descriptions of being a sergeant.
She alleges that she was capable of performing her duties after the injury with a reasonable accommodation.
No, Your Honor. She actually never alleges that she was able to perform the full duties of being a sergeant, and she actually says in her complaint that she was unable to return to full duty. She does plead that she was able to perform the administrative duties on restricted duty. But that, at no point does she allege that she was qualified to perform full duty
I'm
as a
going to
sergeant.
ask you the same question. Given the work that she was doing, the assignments that she was performing for the NYPD, is there any bar in place in the record that's noted in the record as to the ineligibility of sergeants to do that work?
Two things, Your Honor. First, if I understand Your Honor's question correctly, you're asking about the distinction between a managerial level, like a sergeant and an officer. No, Your Honor. Second, I would point Your Honor.
I'm sorry, no to what part?
No, there is nothing in the record that talks about the distinction between sergeants and officers in terms of whether they can perform restricted duty. However, the mayoral directive does explain the policy behind restricted duty assignments and notes that for all officers, including sergeants or managerial positions, that restricted duty positions are intended to be a limited time position to allow an officer who is injured and unable to perform full duty to get back to full duty.
And when was that issued, that policy?
When was it issued?
Please.
1978, Your Honor.
Okay. And we're at the motion to dismiss level, right? We're at the very beginning of this all. So if there was discovery, then we would find out whether or not there's comparators, right? Whether there's any sergeants doing this kind of work anyplace?
Yes, Your Honor, and
So do we need to know that at this point in time?
She does need to allege inferences, allegations sufficient to support an inference of discriminatory intent, and one way you can do that is through comparators. But the comparator allegations that she's included in her proposed amended complaint are woefully insufficient, and she relies on such.
Is that because there's no discovery?
I mean, she's able to allege the names of specific sergeants. She's able to allege that their specific income in specific years. I see that my time is up. May I finish my sentence?
Can I just ask, what about her allegations with regard to the timing between when she mentions her disability and when the objectionable comments are made?
From my understanding of the complaint, there is a period of several months where these comments are being made by different people in the NYPD, and there are other actions being taken, such as the transfers. But she makes no allegations that any of the decision makers for the transfers made any of those comments. And I'll also note, too, that the comments do not allege any connection to her disability. And although they might be kind of generally offensive, this court's precedent requires a higher standard of a connection to the protected class.
Thank you.
Thank you.
As to threats of terminations, we
So
could,
did you not allege that there was a failure to accommodate, that with an accommodation should be able to perform the task?
she does allege that with an accommodation, she would perform the task. Yes, Your Honor.
That's what I thought. Okay.
Yes, and none of this is properly dismissed on a 3211 basis. To the extent that there is any deficiency in the complaint, it does not create futility. It should be brought back to Supreme Court. Leave to amend should be granted. We thank the court for its time.
Okay. Healy v. Kruger. Yes.
Good afternoon, Your Honor. May it please the court. My name is Stephen Altman. I represent the plaintiff appellant, Dr. Kirsten Healy. The decision in the trial court is based in a single conclusion. That conclusion is that the contract between the parties that underlie the fraud claim was for the sale of a medical practice. I implore the court to look at the contract at issue and what we pled in our complaint. The document, the contract, is entitled Amendment to Lease. Our claim for breach of contract that preceded the fraud claim is based on 2 of 3 separate provisions requiring the defendant to pay the plaintiff money. 1 was for rent, that's paragraph 7. 2 was for commitment payments, and 3 was paragraph 8, which did and is an illegal provision. It's for the sale of the business. Nowhere in our complaint do we allege a claim for specific performance compelling the sale of the business or any damages alleged at all with respect to the sale of the business. In fact, claim 3, our account stated claim, which was dismissed previously.
What would you say is the main objective of the contract? What was the main objective of it?
For the defendant to pay rent for the space that he had been practicing medicine in for decades before my client, she's not a young woman, she's a substantial practicing doctor, but a cardiologist in the same space. She came into that
So
space.
this was a rental agreement and not
It's a rental
not a
agreement.
fee-splitting agreement.
Not a fee-splitting agreement at all. That's a reach. It was a reach by the court below, and what it enabled her to do was throw the case out. The rent was broken into 2 separate provisions, specifically rent and commitment fees. Commitment fees, she had to be there. Why it was done that way, I don't know. I didn't draft the contract. The lawyers that did, one was actually a preeminent member of this bar, but that provision is not what we're suing on. It was error for the court to dismiss any claim, and that's what the basis of her decision was.
Here's the problem. There was an agreement that the plaintiff would devote 20% of her time to treating the defendant's patients, and it would increase to 40%, and then she would pay to him, am I right? 45% of the gross revenues. Do I have it backwards?
No, that's
20% of her time to treating defendants' patients, then would increase to 40% of her time.
just
For
the amount
which
of
the
time.
defendant would pay a flat monthly fee.
That's not fee splitting. The provision of
No, well, you had stated this was purely a lease agreement, but it's more to it than that, because it not only in terms of the lease, in terms of occupying the offices, but it's also that plaintiff has to devote 20% of her time to treating defendant's patients, 40%, and then it's going to increase to 40%.
Absolutely true. The question is, I guess, even to really drill down on it even more narrowly, is
So,
that provision,
The
is
monies,
paragraph 7,
so these are patients, these are defendant's patients, right? So now plaintiff is going to be treating these patients, and the monies are going to be,
she's being paid for her services, not splitting. She's being paid.
Then there's a provision for the 12 months immediately
Yes.
following the Kruger buyout
Right.
date. Owner will remit to tenant 45% of the gross revenues received by owner on account of tenant's patients, including hospital and home visits.
Judge Friedman, you're right. That's paragraph 8. That's illegal. I didn't sue on it.
But the problem we have is that, according to Georgia Properties versus Dulcimer, in a 2007 case from this department, the holding was where the main objective of the agreement is illegal, courts will not sever and enforce incidental legal clauses. And that's what the court found here below.
That general provision is correct.
Then doesn't it taint everything?
It doesn't, Judge. That's exactly what the principal cases that we relied on our brief, I see my time is up. Those cases clearly say, if there is an offending provision, you strike that. That's what the court below should have done. It should have stricken paragraph 8 and allowed our claim to proceed on paragraphs 6 and 7. It turns this contract upside down to say it's a sale of a business and a fee-splitting contract. If it did, it would have said sale of business or just agreement. It doesn't say that. It says amendment to lease. And not paragraph 6 and paragraph 7 of that contract are not fee-splitting provisions.
Thank you.
Thank you.
Yes.
May it please the court, Joshua Krakowski for the defendant respondent. And the decision below should be affirmed because this agreement is a fee-splitting agreement designed to sell a medical practice. There are 3 different payment provisions in here, the rent, the commitment fees, but the sale of the practice provision just overwhelms the entire contract.
Did the defendant scam the plaintiff?
Well, I mean, both parties said that they didn't know that this was illegal at the time. So, there's no evidence in the record that anyone tried to scam anyone. The fraud claim that's being asserted doesn't allege that anyone tried to scam anyone. So no, the answer is no. The parties entered into this contract in good faith. They thought they could work it out. They thought they could practice together. Dr. Kruger intended to sell his medical practice to Dr. Healy. They didn't realize that the way they were going about it was illegal. But the entire contract here, you have to take into account. If you excise the sharing of revenues, none of the rest of the contract makes sense. There's no reason why Dr. Kruger would go in and rent space and pay somebody to treat his patients. This was clearly a temporary period where Dr. Kruger was going to, introduce Dr. Healy to his patients, have Dr. Healy treat his patients so that they're comfortable when the time comes to continue seeing Dr. Healy, and then Dr. Healy can in turn pay Dr. Kruger essentially for the sale of his medical practice through division of revenues, which everybody agrees is illegal.
The plaintiff, the plaintiff says, I wouldn't have bought this. I wouldn't have bought this space but for the understanding that this agreement was going to work. And now I'm not getting any money. I'm not getting any rent.
Well, first, there's the question, there's justifiable reliance. We have plenty of evidence in the record where the plaintiff testified, I didn't believe Dr. Kruger from the start. And then her husband, who's also works for her medical practice, testified specifically. We knew that Dr. Kruger might not abide by the terms of this.
Aren't you kind of changing positions on whether she was scammed? You're telling us now that she should have believed that he was unreliable?
Absolutely not. I'm saying this is what the allegations were. And then in testimony, she said, I didn't trust Dr. Kruger from the start. So to have a viable fraud claim, you need to show justifiable reliance. If you think the other side's lying, you don't have justifiable reliance, especially here where Dr. Healy's husband testifies, we actually took actions to protect ourselves from Dr. Kruger by buying the space in the first place. Because that way, and what he testified is, if Dr. Healy is just renting the space, she's a lot more subject to Dr. Kruger's whims.
What are her damages if the space is a good space and it's what she wanted to do anyway? What are her damages?
There are none, Judge, and that's one of the points in our brief is that there's no out-of-pocket loss. She purchased this condominium that she operates her medical practice in for a certain price. It was in 2019. It's on the Upper East Side. There's no evidence in the record as to what it's worth now, but presumably it's worth a lot more. I think everywhere on the Upper East Side now is worth a lot more than it was 6 years ago. So there are no damages.
Did you have a question?
No.
Thank you.
Thank you, Judge.
Just briefly, Your Honors. and I think specifically Judge Gonzalez, you recognize, in the record at 451 is the defendant's gross revenues from 2017 to 2000, from 2013 to 2017. They were relied upon by my client in entering into the contract and are part of the basis of the fraud claim. They show gross revenues of over $3 million. By 2017, just under $4 million. He purports to say, no, all I intended to pay in rent was $4,000. Imagine, it's something close to our hearts as practicing lawyers. Imagine having a $4 million a year practice, but only having to pay $40,000, $4,000 a month in rent. That wasn't what it was. If you add the commitment fee, even adding the commitment fee, it's $20,000 a month for a $4 million gross medical practice. That's what the deal was. That part, those two provisions of the contract should be enforced. Unless there's anything further. Thank you.
Thank you. Burns v. Abacan Apartments or Beacon Apartments.
May it please the court. Good afternoon. Christina Mercado for plaintiff appellant respondent. The lower court erred here in dismissing plaintiff's labor law section 240 claim, finding that he was not engaged in covered alteration activity and not applying the controlling law, including job law, Weininger.
But isn't job law distinguishable from what happened in this case?
Not really. I mean,
when you say not really, I mean, job law included, it had to do with a manhole. It was more extensive.
That may be another case. Job law is the case from 1998 from the Court of Appeals, decided the same day as Weininger, where
that was installing an electric wall clock in the mailroom, right?
Correct. And there wasn't an outlet in the room, so he had to basically run an extension cord. But because it wasn't in the room, he drilled through the wall.
This is what it was. It was chiseling a hole through a concrete wall. That's distinguishable from what we had going on here.
We were drilling through a wall. Just because the wall was made of something different, that's where Weininger...
It goes to whether it's a structural change, a significant structural change that makes it an alteration, right?
Yeah, so in Weininger, there were no holes drilled. Plaintiff was running the cable through chicken wire in the ceiling, through canals and chicken wire. And that decided the same day as job law, under the same significant physical change standard. That is, it's good law, it applies. The court did not explain why it didn't apply, what was different. It was also a data cable.
What case was that you just referenced?
Weininger, 91 New York 2nd, 958 from 1998, Court of Appeals.
That was pulling wiring through canals that had been made in chicken wire, in the ceiling.
In the ceiling, which is what plaintiff was doing here. He pulled wire for more than 36 feet from the Beacon side of the basement, the owner-occupied side, through walls. He drilled holes to put the wire through the walls, and he also pulled it down from the drop ceiling. He put it up into the drop ceiling, pulled it down. He used 3 ladders.
Counsel,
in the Kochman case...
How do you get around the very different versions of what happened here? Don't we have different versions?
No, respectfully, Your Honor. I think what you're referring to is how the superintendent testified that he saw
there was no drilling.
Sorry?
Didn't he say there was no drilling?
He didn't see the drilling. But he went with the plaintiff down to the Beacon side.
He said he didn't give him a ladder to use.
That's right, but he doesn't know if anyone from his...
well, he said all his ladders are locked up.
But he did not know whether anybody else, there were porters working that day. He doesn't know if they gave him a ladder. Page 415.
He was with him the whole time that he was downstairs.
He was not with him the whole time that he was down there. He testified, I was only with him for 10 minutes. He walked back up, and I don't know what he did the rest of the day.
What about the Rhodes-Evans case, since we've been talking about cases?
Okay.
Isn't that case similar to what we have here?
Not at all. Not at all. The Rhodes-Evans case, and Spencer as well, involves splicing a wire. it's, I think, common knowledge what that is you cut two wires and you basically like twist the insides together. There's no work on a building at all. You're only working on the wires. And this court has already specifically distinguished the type of work in our case from the Rhodes-Evans
Well, how about
splicing cases, and that's
how about
Kochman.
Castaneda, where there was work on the building, there was work on the building facade?
In what case?
Castaneda versus Amster Co. 67, where anchors were drilled into a building facade to attach pest control netting.
Yeah, it's a 2023 case.
Worker allegedly injured were performing work for pest control. Attaching pigeon netting to anchors drilled into the facade of a building and setting up spikes on buildings, ledges, and windowsills did not affect significant change.
Thank you, Your Honor.
Configuration.
That
And I
was
also wanted to go back to Rhodes Evans. You made it sound like it was like wires, splicing. We're talking about heavy cable wires in Rhodes Evans, which is a little different.
It's a fiber optic cable.
Right, but cable wires are a little thick. And the court said that was didn't bring it under.
It was not altering a building or structure because that wire in that situation was not a building or structure. Here, we're actually drilling through the walls of the building and running the wire through the ceilings. And the Kochman case decided by this court in 2013, it was a Verizon technician, and this court held that because plaintiff was, quote, not merely splicing cables into an existing circuit, he was running new wires through the structure. That was a covered activity. It cited to Rhodes Evans and explained why, the same reasons I'm saying.
Which case is that?
It doesn't apply. It's Kochman, 110 AD 3rd, 477.
All right, 110 AD 3rd, what?
477.
Mm-hmm.
First Department, 2013. And just the last thing to address, the pigeon netting case, that was a routine maintenance. It was a maintenance worker janitor that was doing that work. He was not installing a new system, which the plaintiff in this case was doing a brand new
But he was installing 60 to 300 anchors on windowsills.
But it was part of routine maintenance of the building. His job was as a janitor. The plaintiff's job here was he came to the site. He was hired to install a new system.
Was he hired to install a new system? Is that what he was coming to do?
He was installing a new wireless system on page 5.
No wireless system, right?
A wireless internet system, but he had to hardwire from the beacon side of the
Was
property.
he hooking up to the Verizon equipment in a different room? Existing Verizon equipment in a different room?
He was hooking up new equipment to existing equipment. The existing
Connecting
equipment.
to the building's existing router, which was in the
It wasn't
equipment room.
It wasn't a router. Well, I don't know what it was.
What
but
was
it
the new equipment? You say what new equipment was being installed?
A router.
Right.
Was new. That was what was new.
Right, but it was being installed into equipment that was already there.
Right, you connected to the router.
So was Joblon. He was connecting that electricity to the electricity that was already existing.
Thank you, and we'll hear from your adversaries.
Good afternoon, Your Honors. May it please the court, my name is Robert Modique. I'm an attorney for the respondent appellant blended family. I actually have two separate arguments that I'd like to address today, but to address the first, which is what plaintiff appellant's counsel was addressing, it's our position that the lower court properly dismissed the labor law section 240 sub 1 causes of action. And with regard to...
So, counsel, how do we distinguish this case from the other alteration type cases where the court has found that it was the work that was being done was alteration?
I think...
Like, what do we look at? Do we look at whether it was being connected to already existing material? Do we look at whether there's drilling? What are the factors that we look at to determine alteration?
I think ultimately, the answer is yes, you do look at those things that Your Honor just mentioned, but overall you look at the totality of the work being performed. And in all of the cases that were cited by counsel, there's significantly more work being done than was done here. In this case, this is an 8-story building. It has 120 residential units and 1 commercial unit. And despite the size of that building, we are talking about 1 Ethernet cable. That's it. That's all the plaintiff was installing at the time that this incident occurred.
But how was he installing it? What mechanism is he using to install? Is he drilling? What is he doing?
He says he was drilling. If you remove the drop ceiling, there are the rafters, the wooden beams in the ceiling. He says that he drilled through that. Defendants have no knowledge whether or not he did or did not. Certainly, defendant Blended Family, which is the tenant, had no knowledge because all of this was going on in an area of the building where Blended Family has absolutely no access to.
Does the how of the work being performed matter to whether it's alteration work? So the fact of him drilling it, does that make it alteration?
No, absolutely not. And there's case law that we've cited in our brief where similar type work was performed. Your Honor mentioned anchors that were being installed that required drilling in one of the cases. So the mere fact that a drill was used does not make it an alteration to the building.
To the extent that the basement was divided into 2 separate parts, one being the commercial part and one being the residential part, does that make a difference as far as alterations are concerned?
No, Your Honor, and I'm not aware of any case law that suggests that it does. But it is important, particularly from Blended Family's position, that the lower court got this right, not just because the work being performed by plaintiff is not covered by Labor Law 240, but also the court correctly noted with regard to Blended Family that Blended Family is not a proper labor law defendant under the statute. As I'm sure the court is aware, Labor Law 240 provides for strict liability against owners and general contractors. And then there are some additional descriptions depending on who you are. But in this case, Blended Family is certainly not the owner of the building, and they are not a general contractor.
Oh, the court stated, as you know, that Blended Family hired Verizon to perform this work.
Sure. And Blended Family had no choice because Verizon is the entity that provides cable services and internet services to this building. Blended Family had no choice there. They're a daycare.
Well, does that matter, though, the fact that the way they split it up, that Verizon is the carrier for that building? Doesn't really matter, does it?
That in and of itself, it could be Cablevision, it could be Verizon, that doesn't matter. But what matters is that Blended Family is not a proper defendant, an enumerated defendant under the labor law. They're a daycare. They're not the owner, they're not the general contractor. This is not construction work that is being performed. And perhaps most importantly is the fact that the area where this alleged accident occurred was in an area of the building that was in the sole and exclusive control of the owner of the building, Abikin. It was not in that portion of the building that Blended Family leased from Abikin.
Or had control over, right?
They had absolutely no access. In fact, the record is clear. In order to access that part of the building, you have to actually leave Blended Family's commercial space, go outside, and then come in the building in another location, and that location
Because there's no way to get from the residential to the commercial area of the basement without going through. There's no interior doorway or something.
There's no way to do it. There's no way to access where this work was being performed from Blended Family's space. You had to actually leave the building, and the only way to get access to the area was by Abikin, the owner of the building.
Thank you.
Good afternoon, Your Honors, and may it please the court. Ross Frischer for the owner, respondent here. The motion court properly dismissed the 241 cause of action against the owner and properly awarded partial summary judgment on the issue of contractual indemnification. And I'm just going to start with the Public Service Law 228 because that law specifically says that no landlord shall interfere with the installation of cable television facilities.
Right, but it doesn't, it makes reference specifically to television facilities, right? And it doesn't talk about Verizon.
Yes, so that term, cable television facilities, is further elaborated on in a different section of that article of the law, which is section 212 and 213. And 213 says that this article shall apply to every cable television system and every cable television company.
But Verizon is a telecommunications company.
It would, there is no dispute, at least in this record, that Verizon is a cable television company that was franchised by the city.
Right, but I don't know that it's recognized as such in terms of the statute. I mean, in terms of the legislative history, et cetera, I'm not really sure that Public Service Law 240 subsection 1 really covers Verizon.
Okay, well, even in that case, the cable television system portion of it, so it's a cable television company that is managing a cable television system, which is extremely broad, and the court notes that. But I want to move on to the alteration.
But this was not about installation of cable, right?
It was, so the way
This was a
cable,
wireless system.
right, so the way cable television system is defined is any system which operates for the hire of service of receiving and amplifying programs broadcast by one or more television or radio stations or any other programs originated by a cable television company or by any other party, and distributing such programs by wire, cable, microwave, or other means. Extremely broad. So it could be construed, and it should be, to include this. It's just that the intent of this article was to not have landowners precluding entry
Right.
by cable television facilities.
We've moved quite far since where you actually need cables, right? In order to get cable TV, you can have wireless.
That's right.
So you were moving on?
Yes, so with respect to the alteration argument, I just want to point out on page 27 of my respondent's brief, we go into the question that this court was asking, which is how do we distinguish this case from other cases cited by the appellant? And it comes down to this. It's whether the work performed affects a crucial building system. And that is delineated by this court in Manangaya v. Bronx Lebanon Hospital, excuse me, Your Honors, 165 AD 3rd 117, where this court held that work that only affected the provision of service to a finite area within a building was not part of an important building-wide system and did not constitute an alteration. So going back to the cases that we discussed, Weininger, there, it's undisputed that it was in the record that the plaintiff was establishing a new telecommunications center for the building in that case. In Kochman, same thing. It concerned, quote unquote, the realignment of the entire telecommunications system in the building. In Keilitz, installing a fiber optic network through a 20-manhole structure where none had previously existed, and I can go on, but it's in the brief. And the question here, it's undisputed that this concerned the installation of a single Ethernet cable specifically for my client to have internet access, not the whole building. They weren't restructuring anything. So in that case, it's clear that even if the public service law didn't apply here, that this was not an alteration under
But you represent Appicon, right?
Abacan, yes.
Right, Appicon, okay,
Yes.
thank you.
And if there are any further questions, I will rely on my brief.
Thank you.
Thank you.
I just need to correct the Mananhaya reference. That case involved a chiller outside of Bronx Lebanon Hospital. There was no drilling.
But it's still stated, I mean, he's correct. It
That's not the
states that it
holding.
must not be simple, routine, cosmetic, or decorative, must effect a significant physical change to the configuration or composition of the building or structure.
That's the same language from Jablon, and Jablon held that it did affect a significant
But,
change.
you know, Counsel, I have to say,
through the
I
wall.
do have issues with your arguments, especially in terms of blended family. So I, as a resident or, you know, the owner of a daycare center, I hire Verizon. I call Verizon because my cable's not working. And Verizon comes to fix my cable. And I know that the routers are in the basement of my building, right? And so the Verizon tech says, I have to go down to the basement in order to fix this. The tech goes down to the basement, and, you know, my super or whomever, or Verizon brings their own ladder, I don't know, but someone gives them a ladder, they're on the ladder, and as they're working, they are injured. I now am
No.
responsible for their,
No.
their injury?
You're not for two reasons. One, you're going to be a single-family homeowner, or
Okay, but again, so, but now we're talking about
but
blended
two-
family.
but blended family. You're talking about a repair. We're not in the repair. We're in a.
Okay, we're not in the repair. They're coming to install cable. They're coming to install wireless now.
You move into a
like
new
all the rest
building
of
and you need
240.
your wireless cable done,
It's
right?
just like
And
the
they're
rest of 240. The
I'm
person,
sorry?
everything else in labor law 240, the contractor that hires the plaintiff's employer is generally on the hook, whether they
I'm not
were-
the contractor. As my colleague just stated, I move into the
owner.
building and I have Verizon come in to wire cable. For some reason, that apartment was never wired, and so
If
now
some-
they're coming in to wire cable.
And if-
I'm going to be responsible?
If you, the daycare, hire a painter to come paint, you'll be responsible. If you, the daycare, hire a window washer to come wash your windows under the labor law, you're responsible as the lessee.
And they go
in
down to the
possession.
basement to do, well, I mean, they're painting in
your space.
your space.
There's nothing cited for this, but an owner, when work has to be done on the adjacent site or protection has to be put up, we cite cases in our brief that the
Is
owner
this
of
the
the
intent
project-
of the labor law, so that any worker who is engaged in, we're going to assume this is alteration, I'm not even sure this is alteration, but any worker who is engaged in this is now, the individual who hires that worker is now going to be responsible?
The owner is responsible.
Didn't he bring his own ladders as well to do the work?
He did bring his own ladders. He testified that he had two and he needed another one and borrowed it from the building. So this work required 3 different ladders, pulling a wire through 2 different parts of the building, through a wall. He made more
I'm the
than one-
daycare owner, so now I'm responsible for all of that, is what you're saying.
Any lessee who hires someone to do work that's covered by the labor law is going to be on
Well,
the
I guess I'll have to do without cable then. Thank you so much. I'll have to stream everything on YouTube or something.
But you need cable for that. You need
I
wireless.
need cable for that too?
Yeah,
What
you
am I
need
supposed to do?
internet connection.
Then what am I supposed to do?
Nothing.
Well, you know what? I could read a book. Yes, counsel.
Your Honor, I agree with you, by the way. This is not the intent of the labor law, but
I don't think, but I also, the way it's written, perhaps, there is liability there.
But I wanted to come up, and I said earlier that I had 2 things that I wanted to address. We are also the appellant with regard to what we believe to be the lower court's erroneous decision in which it granted the owner, Abacan, contractual indemnity against blended family. We believe that
Conditional or
I didn't hear you.
conditional?
It was conditional indemnity, yes.
Well, because do we know if there's any liability on the part of Abacan?
As we sit here today, we do not, Your Honor. It is conditional, and it's
Right.
based on Abacan's negligence. So the only claim remaining right now to go to trial would be whether or not is plaintiff's common law negligence claim against Abacan.
Right.
And because that is the only claim, our position is that the lower court clearly erroneously decided that there would be conditional indemnity because the contract or the
Wouldn't
lease.
Abacan have to be found negligent in order for blended family to avoid liability under that indemnification provision?
If Abacan is found negligent,
then blended family gets out of it.
well, that's not what the lower court's decision said, and that's why it's erroneous. But I agree with Your Honor. If that were the case, that would, A, violate the general obligations law 5-321, which, by the way, the lower court ignored the argument on 5-321 and erroneously referred to 5-322.
I thought there was a savings clause. Wasn't there a savings clause?
Yes.
The savings clause is, that's with regard to general obligations law 5-322.1, which has to do with agreements between owners and contractors.
Right.
This is a lease agreement between an owner and a tenant, which is governed by
It's conditional.
5-321.
It's conditional. Summary judgment was granted conditionally. So what is the problem with the condition?
Because the agreement, the lease agreement, does not provide anywhere within it, under the indemnification provision, for the tenant, blended family, to ever indemnify Abacan for its negligence. There are 4 sections under the indemnification language, A, B, C, and D.
So what did Supreme Court condition it upon?
It should have just denied that application, is what it should have done.
You
And now
want the indemnification dismissed.
the indemnification claim,
You want it dismissed, and
Yes, sir.
Supreme Court granted Abacan conditional summary judgment on it, did it not?
correct.
Right.
So
And that was an
what is the condition?
The condition would be that Abacan be found negligent. But the lease agreement doesn't provide for indemnity if Abacan is negligent. The lease agreement only provides for indemnity if the tenant, blended family, is negligent. But there is no negligence claim against blended
But
family.
it said, shall tenants, to the fullest extent permitted by law, shall indemnify and hold harmless landlord. So who's the landlord?
I'm sorry, Your Honor, what section are you reading?
I'm, the record at 633-634?
Right, but there's 4 parts to the indemnification.
Right, A, B, C, D, right.
A, B,
But
C.
I'm reading the paragraph that prefaces those 4 sections.
Oh, yes, Your Honor. But it's limited to A, B, C, and D. And A, B, C, and D, A, B, and C clearly only reference when the tenant, blended family, is negligent, or one of its contractors is negligent, but the court's already dismissed that.
What Supreme Court did, if Abacan is found negligent, is it going to get indemnification from blended family?
The way the court issued its decision, yes, it would, and that's the error.
But isn't D the operative part here? Any accident or damage to any person or property, including in, at, or about the demised premises?
And this, as we've talked about for almost 20 minutes now, this accident did not occur in, at, or about the demised premises. This accident happened.
Basement?
I'm sorry?
The basement?
This accident happened in an area under the exclusive control of the landlord, to which blended family had absolutely no access, no ability to access.
you're
So it's not within the demised premises.
The demised premises only would have been blended families premises.
Yes, Your Honor.
Thank you.
Interesting.
Thank you.
Staten v. City of New York.
Good afternoon, Your Honors. I am Andrew Orenstein from Harris Beach, Merthyr Collina, for the respondent, City of New York. I wanted to point out, Supreme Court properly dismissed this case because the plaintiff clearly and unequivocally had notice of respiratory symptoms in June 2017. But additionally, he also associated those symptoms at that time with a toxic exposure. And therefore, there can be no question that he had notice of the condition on which the claim is based. And therefore, his notice of claim was late without leave of court, and the case was properly dismissed.
Did he take any sick days?
At that point, he did not. But as the court...
Did he receive any treatment?
He did not. But as the Court of Appeals clearly and unequivocally said in Re DES, that the CPLR's reference to discovery of the injury is intended to mean discovery of the condition on which the claim is based and nothing more. Your Honor, I'll remind the court that this was an amelioration, a softening of a very harsh standard under the common law, where a toxic tort cause of action arose at the moment of exposure, even where an injury was latent, right? So there would be, the cause of action would accrue at the moment of exposure with no symptoms.
Well, that's not where we are, so why don't we argue from where we are with the law today, currently?
I'm pointing out that the fact that the plaintiff didn't get any treatment, didn't take any sick time, is legally irrelevant.
Well, it's not legally irrelevant if in fact we find that what he was feeling didn't rise to the level of something that was real and severe, and it was more something that he was sort of inconsequential.
Which is why I'm pointing out that in this case, not only did he have significant symptoms, he also was on notice and aware at that time of the connection to a toxic exposure. That more than satisfies the requirement that he be aware of the condition on which his claim is based.
Did he complain about the condition?
Yes, he did.
But when did he complain about the condition?
In July, prior to the bar date for his notice of claim. And that is demonstrably clear because the very latest date in July that he could have made that complaint was the 22nd. And the reason that we know that is because he testified to a couple of things. First, he testified that he worked nights. And second, he testified that the last time he was working prior to being hospitalized subsequently was the 21st into the morning of the 22nd. And he said that the person he complained to was the building officer, Sikos, who was only there in the morning.
He testified that he complained about the situation before July 26th.
Yes, and importantly, on or before July 22nd, which is the operative date, which made his notice of claim late without leave of court.
Thank you.
Thank you, Your Honors.
Joyous JD Limited versus Yolanda. Yes.
Good afternoon, Your Honors. This is Mastoal Tadessa Tarefe for the appellant, Yolanda and Mr. Zhang. Just to start off, Your Honors, I want to remind the court that this is a case that concerns a controversy about whether a British Virgin Island company with a China-based principal was allegedly taken advantage of by another BVI company whose alleged actual controller and principal is also based in China.
So you moved to renew and re-argue the prior decision of the court. And in doing so, you attached, so apparently the court had denied the motion based upon the lack of documentation submitted. Documentation was submitted in Chinese, I don't know, Chinese, Mandarin, what have you. But anyhow, there was no translation. And so then you moved to renew and re-argue, and now you attached documents which were translated to English. Is that correct?
It's partly correct, Your Honor. I just want to clarify two things. So we moved to dismiss based on forum nonconvenience, as well as collateral estoppel.
What did you submit in your motion to renew?
We
that was
submitted-
different from what you had originally in your...
Right, other than the translated documents.
Nothing. So we only supplemented at the renewal level with a translator's affidavit
Right.
To a Chinese judgment that was already submitted to the trial court.
Right, but what language was it submitted?
It was submitted both in English and in Chinese. However,
You had no translator affidavit, so the
We
court
had,
didn't
yes,
consider
had a
it because you didn't
certification.
have the translator affidavit.
Exactly.
Correct, Your Honor.
Right?
So the only difference is that the court refused to consider the Chinese judgment that was presented to it in both English and Chinese because it was lacking a translator's affidavit.
That's a big deal, counsel. It's not insignificant. I mean, I could translate something and make it all up.
That's correct, Your Honor, and that's why we cured the
There's a
deficiency.
reason why you have the CPLR. 2101 of the CPLR says that an affidavit or exhibit that is served or filed in a foreign language shall, not may, shall, and that's mandamus language, right, be accompanied by an English translation.
And so you started to say that you
And an
cured it.
affidavit.
You started to say that you cured it, but did you in fact cure it? Because you didn't, first of all, you're submitting documents that you had, obviously you had possession of, and you did not submit on your initial motion. And secondly, you didn't state or give any reason as to why there was no translation for when you initially submitted the document.
Yes, Your Honor, but under the case law that we submitted, there is requirement to show that there's a new fact. In fact, we say the court was informed of the civil judgment from China and it was given in English translation, but you're correct, Your Honor, it was not in the proper form as CPLR required. It was missing one thing, which is a translator's affidavit.
That's a big one, and that's a big one thing.
It is correct, Your Honor, and that's why we cite to case law on the motion to renewal stage that has excused law office error that is much more serious.
Did you, when you submitted your motion to renew and re-argue, did you claim some type of law office failure? Did you state the reason why there was no translation submitted?
Yes, Your Honor. What we submitted in sworn statement from counsel was that we submitted only a certification by mistake inadvertently, and we claimed we submitted there that it was inadvertent, the omission of the translator's affidavit. And Your Honors, I would.
I'm sorry. Did you state why?
It was.
Maybe I'm not asking the question. On your motion to renew and re-argue, did you state why there was no translation of the documents originally submitted on your motion?
Well, just to correct Your Honor, we did submit the translation.
The affidavit, yes.
The
You know what
affidavit,
she's
yeah.
talking about.
Did you state why?
Yes, we say there was an inadvertent mistake by counsel, which is excusable neglect that other courts have looked at. In fact, in more severe circumstances at the renewal stage, courts have excused it. In fact, we have the first.
You said an inadvertent failure.
Correct.
Did you say that it was did you say that it was law office failure? Did you say, or you said was inadvertent failure?
Correct, Your Honor. Inadvertent to say that the counsel made an omission that was inadvertent. It wasn't deliberate. It wasn't intended to prejudice the other side. We didn't use the term law office failure, but we.
Or you said was inadvertent failure.
That's what we say. Inadvertently omitted.
Right, so on a motion to renew and re-argue, it doesn't give you an opportunity to raise the same arguments again. It's something that, to renew, it's something that you've come into possession of that you didn't have before, and you had no way of knowing that you didn't have it before, and now you're submitting it to renew the court's look at this motion. But you had this stuff before. You knew this.
We didn't have the translator's affidavit, Your Honor. So the fact that we had the judgment, correct? We had the judgment and we did submit it. What we missed was this translator's affidavit.
Okay, so then what about the point of you had no way of knowing that this information was out there? You knew that you needed a translator's affidavit.
We did not, Your Honor. That's what we're saying. We made a law office error in that we did not know the CPLR.
That's not law office error. I don't think that constitutes law office error if you're not familiar with what the law is.
Your Honor, we cite to Garner versus Latimer from this court in 2003 that said even the failure to have a reasonable justification is not, it doesn't set an inflexible rule. That court says even when we didn't submit, if we didn't have ground for justification in the interest of justice, and this case does merit exercise of that discretion because, Your Honor, what the court did by refusing to look at our translated copies is that it completely ruled out several arguments that show that the issues and the claims have already been litigated by a court in China. And the court had the advantage of the English translation. The other side did not contest the accuracy of the translation. And the other documents we added in the motion to renew stage were not required for that analysis. But what the court did is refuse entirely an entire line of ground for dismissal on account of an omission of an affidavit that was later on supplemented. Your Honor, this case—
You have time on rebuttal. Thank you.
Good afternoon, Your Honors. Lawrence Yuan for plaintiff respondents. I'll be very brief. One, it is not for debate that the 4 Chinese language documents are not new in their renewal motion, but known to defendants from day one and submitted to the trial court. 2, their so-called law office failure is essentially conceding the lack of due diligence. And without due diligence, there's no reasonable justification under the case law.
Counsel, what's the harm here if the court had this information before? It had the translated information. It just didn't have something to, I guess, certify that it was an accurate translation, but the information was known to the court.
Your Honor, the harm here is, 1, to get over the renewal statute and you satisfy 2 cumulative requirements. This satisfies none. 2, the fact discovery is closing next Friday. Parties have already done all the factual depositions, and to allow them to reverse the trial court decision and not hold them to the statute is essentially saying every party can validly submit or resubmit evidence that are already in their possession and trap the other side in endless motion to dismiss. So they need two requirements. They get neither. Three,
I mean, what about the point here that we're litigating something that was already litigated in China?
That's excellent
and was
question,
not in your client's favor.
Yes, Your Honor. So they're arguing substantive fairness in their reply. Two responses on that. One, they never addressed that there are 6 New York common law claims and 2 Securities Act claims that the Chinese judgments does not and could not have touched on. And case law says if one part of the litigation must stay in New York, FNC dismissal is not warranted. 2, they are not barred from raising the res judicata and collateral estoppel argument on summary judgment. The fact discovery is closing next week. Frankly, their arguments and our counter arguments based on res judicata and collateral estoppel could both benefit from a more developed factual record on the identity of parties, identity of claims, due process in the Chinese proceeding, and the opportunity to litigate. So even the policy and equity.
What do you mean by due process in a Chinese proceeding?
They argue collateral estoppel argument, and collateral estoppel requires the full opportunity to litigate. So that can only be developed under after discovery. So even the policy equity and judicial economy favors affirming the trial court's decision as opposed to reading the renewal statute out of existence. That's all I have, unless your honors have any other questions.
Thank you.
Your Honors, just to answer your question about prejudice, that question has to be presented at the stage of the motion to dismiss and motion to renewal stage, not after what happened after the order. So anything that developed in discovery is not relevant to this court's analysis. However, because they brought up discovery, if the court has to be aware of what discovery has it led to exactly confirming why this case belongs in China. All the 4 witnesses that we deposed in this case were based in China, not a single New York witness. Depositions also showed that the other side is going to rely on Chinese law. So a few of the depositions, they refused to answer questions saying Chinese law expert is needed, 5 or 6 times in one witness case. Another time.
What about counsel's argument that there are separate and apart New York causes of action here that can only be determined here?
Yes, Your Honor. There is abundant case law, including the Piper aircraft case that we cite to from the Supreme Court that says at the FNC analysis, the fact that a party may not be able to assert all its claims in the alternative forum or may have bad discovery rules or some inconvenience because of the foreign jurisdiction is not going to be given substantial weight. In addition to that case law that's very robust, New York also has law, this is the Norex case that we cite, that says alternative forum is not even required. If they were able to show that Chinese courts were not open to them, that does not mean that the FNC analysis stops there. There's clear case law that says the fact that they're not able to assert some claims in China is not what the test is for
Counsel, what you filed a motion to dismiss, right?
Correct.
So that motion to dismiss was denied, and now you both have a chance to do discovery, right?
Correct, Your Honor. However, we
then
don't
you can do a motion for summary judgment either side if it's appropriate, right?
Correct, Your Honor. But
so you're not out of the box.
We're not, but they are playing a game here, which is not just forum shopping, because they first sued in China. They lost that case, right? And now we are in the situation where all of the parties are in China. When we depose them, they rely on Chinese expert analysis and refuse to testify about the Chinese litigation, citing to Chinese law on confidentiality and privilege. And that's why we told the court in the motion to dismiss stage, none of the parties are in New York. None of the events underlying this transaction are in New York. Therefore, Chinese law governs, and China has already seized jurisdiction on it. And so you're right, Your Honor. Discovery actually shows exactly why this case does not belong here. Depositions were starting at 5 a.m. here in New York, with a 12-hour difference, none of the parties that we depose are in New York. They didn't even notice a single New York-based witness.
Thank you very much.
Thank you, Your Honor.
Last case for argument, People v. Wesley Cooper.
Good afternoon. Karen Brill with the Office of the Appellate Defender for Wesley Cooper. The error in this case is basic. When the trial court learned that Mr. Cooper had issues with counsel, it needed to let him explain what his complaints were before it could validly
Defendant
deny them.
actually asked for a new attorney?
He didn't get to that, no, but the court understood that that's where this was going and denied it as a substitution request. The court said, I'm not relieving your counsel. And so that's the same exchange. For example, this court in People v. Bronham said that when the court evinces understanding that it's a substitution request and denies it as such without...
Well, I mean, it says, in terms of the transcript, it says, Judge, I want, the defendant goes, Judge, court says, speak to your lawyer. His attorney says, Judge, if he wants to speak, he wants to speak. Court says, speak to your lawyer, have him speak to you, and then he can tell me what he wants. Then the attorney says, the defendant has expressed concerns that he's not being represented properly. I think I'm interpreting, and then the defendant says, I'm competent to speak for myself. Attorney, only if the judge allows you. Defendant, I feel I'm not getting a fair trial. And then later on, the defendant says, don't I have a right to speak up? I have a right to speak up. I feel I'm not getting a fair trial. I'm not even prepared for trial. My lawyer is ineffectively counseling me. Then the defendant goes on also representing me. Court says, I'm not relieving your counsel. Don't interrupt me. Then the defendant says, I asked for a lab report. He gave me a field test. How is this a request for new counsel?
I think because what the court understood is that you don't raise that your attorney is ineffective because you want to keep your attorney. And so I think that's why the court said, I'm not relieving your counsel. It's an understanding that that is why he was bringing up these complaints.
He doesn't make specific complaints about his counsel other than the field test being given instead of a lab report. They're just really generic statements.
Yeah, Justice Friedman,
I mean, he doesn't point to any conflict. And he had already, this was the second attorney. Supreme Court had earlier changed his attorney.
Yeah, so I completely agree that these are not serious complaints. And so I want to be really clear about what we're saying the error is. I don't think that he was required to get new counsel based on this record. I don't even think the court had to ask questions based on this record. I think the error is more basic.
And this happens, is the jury about to come into the courtroom and this happens? The jury is lined up in the hallway?
Yes, and so that's actually similar to in McCummings. What this court said is that you need to, at some point, give the person an opportunity to make those complaints. And if it's not opportune at that point, that's okay. You can do it later.
So what's the error here, according to your argument, then?
That the court denied Mr. Cooper the chance to even make a record.
And are you basing this on a Brahman case?
On Bronham, on McCummings, on Bryant, but I think—
Is there anything that distinguishes this case from Bronham?
I don't think so. I know that in respondent's brief, they point out that in that case, what Bronham said was that there was a conflict. What this court said in the decision is that we don't know if that conflict could have just been unjustified satisfaction. The problem was that he wasn't allowed to explain the complaint. So here we have that very broad ineffectiveness claim. Maybe it was nothing, but maybe it was something. And what this court has repeatedly recognized is you have to let the record develop.
So where we have information in the record that the court understands that there is some sort of conflict between counsel and the defendant, that the court has to give the defendant an opportunity to express what that disagreement is. And failure to do so means that the conviction has to be vacated?
Yes, so in McCummings, the way this court worded it was the opportunity to make specific factual allegations. And I think that goes hand in hand with the heavy burden on the individual to get substitution of counsel. You have to put forward specific factual allegations that would justify good cause. That's going to take more than a sentence.
Do we have to look at the timing and the circumstances of this record to delineate whether it's like a delaying tactic or something else?
So in this court's decision in Rodriguez, it talks about that. What a trial court can do is certainly factor in timing, factor in attorney history into that good cause determination. But what the court cannot do is at the outset say, I'm not even going to consider the motion because of that history. You have to let the person make the record.
So the jury is outside. They had gone through jury selection. There were preliminary motions, et cetera, preliminary proceedings and jury selection. nothing from the defendant as to his wanting a new attorney or his being dissatisfied with his attorney, right? Is that correct? And so now, as the jury is walking in the courtroom, all of a sudden, at this point in time, the defendant states, oh, you know, I want a new attorney. He doesn't even say that. So again, wasn't the court justified in looking at the situation and what was going on and thinking that it was, in fact, a delaying tactic and not, and therefore not perhaps affording the defendant additional time to speak?
Not under this court's precedent. I'll just note in McCummings, they were already on the 4th day of trial. And this court still said that that timing cannot categorically justify a court's refusal to consider the request.
So the error here was not giving the defendant an opportunity to make a full record. Is that your argument?
That's our argument. I think full record is maybe even overstating it. I think it's a very minimal ask to just say, why are you asking for counsel to be relieved?
Well, did he ask for counsel to be relieved? Do we have to have evidence, some sort of direct reflection in the record that there was a request to relieve counsel?
Don't need that, and we didn't have that in Bronham. What this court said in Bronham was that once the court evinces its understanding and denies it as a substitution request, the same way that this court said, I'm not relieving your counsel, that is improper if the court has not first discerned the basis for the raised issue with counsel. And again, I think that makes sense because you don't say your counsel is ineffective if you want to keep your counsel. Thank you.
Thank you. Yes.
Well, good late afternoon, Your Honors, and may it please the court, Alex King for the people. Defendant did not request a third attorney in the middle of his trial as the jury was outside waiting to...
Well, why don't you pick up on where your adversary left off? Your adversary is arguing that once the court itself evinces an understanding that there is some conflict or a request for new counsel, but doesn't give the defendant an opportunity to address that, then that is reversible error.
So,
and she's pulling that from Brahman. Can you distinguish it?
Yeah, so Branham is distinguishable on the ground that in that case, the defendant said that he had a conflict of interest with his attorney, which is one of the two clear-cut instances the Court of Appeals identified as requiring a substitution of counsel. The key thing is what the defendant himself says, not whatever is in the judge's.
The key thing is what the defendant himself says, but the argument is that the court did not allow the defendant to make a full record. Cut him off.
The argument is wrong. He had sufficient opportunity to speak. He even went so far as to repeat his grievances.
Well, the court said, don't interrupt me. Speak to your lawyer. How did he have an opportunity to speak where you have the court at every turn saying, don't interrupt me, don't speak, speak to your lawyer?
So let's see what he said here. He said to the court on the record, I am not getting a fair trial. I'm not getting a fair trial. I'm not even prepared for trial. My lawyer is ineffectively counseling me, and he is also ineffectively representing me. That is a significant number of complaints that belies the suggestion that he had no opportunity to speak his mind, which distinguishes this case from the prior cases of this court.
But the response to that from the court is, you're not getting a new lawyer.
Correct. And the court was correct to say so, that these were not a reason to give him a new lawyer. And defendant went on to confirm that when he said, after the court said, I'm not going to provide you with a third attorney, he was upset because his attorney had given him a field test instead of a lab report.
And the court tells defendant, speak to your lawyer?
Yes.
So, and the lawyer doesn't bring the subject back up?
The lawyer brought the subject up in the first place. The lawyer said,
at that point, but it doesn't come back to it. I mean, because this is happening as the jury is about to walk into the courtroom. Right. I mean, there was nothing which would have stopped counsel from coming back when the jury left the courtroom and saying, look, Judge, I want to bring up, my client tells me that he doesn't want me as his attorney anymore. There's nothing which would have prevented him from doing that.
But for the fact that the judge said, I'm not giving you a new lawyer, like that closes the discussion. Right?
Maybe at that moment, but counsel could come back later and say, I want to revisit this issue, and defendant himself could also make a statement. This is a defendant who frequently addressed the court.
I know in the brief you say he has 51 prior whats with the criminal justice system.
I believe convictions, 51 prior convictions.
Can you distinguish McCummings? I know we talked about Rahman. What about McCummings?
So in McCummings, the defendant had no opportunity whatsoever to explain why he wanted new counsel. He said, I want new counsel, and the court said, no, I won't hear any more of this. That is not this case at all, when we had defendant go so far as to repeat himself about what his complaints were.
The 51 prior convictions plays what in terms of the calculus of this discussion?
It's a significant circumstance for this court to consider. This is a defendant who is extraordinarily experienced with the criminal justice system. We know that not.
So that means that once the judge told him that I'm not giving you a new lawyer because he's been through the system 51 times, that it was on the defendant to say again, I want a new lawyer, and push the record further because he has this, as you say, 51 prior experiences?
He should not have said that at that time as the jury was waiting to enter the courtroom for the trial to begin, but he could have said this later. He also could have said.
Okay, so because
to his
he
attorney.
has 51 prior experiences with the court, he should have known, or he knew somehow, that later after the court said, I'm not giving you a new lawyer, that sometime later in the proceeding that he still had the ability to say, I want a new lawyer?
The 51 prior convictions are a relevant consideration in the sense that this is not a novice. This is not somebody who does not know.
Yeah, I know that's what you're saying, but what I'm trying to understand is the legal import in this situation.
I mean, it cuts both ways, because he has been through the system 51 times, and he would know that once a judge says, I'm not taking I don't want to hear anything further from you, that means that it would be it would not be to his advantage to, again, bring it up in the future, right?
Certainly not. Now let's put to one side the 51 prior convictions and just focus on this case itself. Defendant had spoken his mind many, many, many times. He had already had his attorney replaced once. He had repeated on, I believe, 5 occasions that he wanted his attorney to bring up this battle hearsay at his trial. So this was not somebody who was unable to explain.
When was that in terms of the hearsay?
I'm sorry?
You just said that he had repeatedly spoken about hearsay. When was this?
On 5 occasions in the pretrial proceedings, he raised the issue of his fellow drug dealer's affidavit. Defendant was either unwilling.
And that's when, and also at this time when he makes reference to the field test as opposed to the lab report?
Right, and this was just as baseless as his prior request. Defendant admitted.
Just for clarity, your argument is that there was no need to have further inquiry, or that he did have some opportunity to speak, that he was speaking?
Yeah, it's both. It's first, he didn't request an attorney. Second, even assuming that he did not make the sort of specific factual allegations that would suggest that he had a serious
and he
complaint
would need
about
minimal
counsel,
inquiry.
Mr. Fredericks. And even if the minimal inquiry requirement was triggered, that happened here when defendant went on to speak about the field test in the lab report, which was not a reason for his counsel to be replaced.
And with his experience, he would have known that the fact that the judge said, I'm not giving you a new lawyer, didn't mean that he couldn't have his attorney revisit the subject that very day when the jury left the courtroom.
Of course. If there are no further questions, we ask
Thank
that you
you.
affirm.
So, counsel, is there any significance, you think, or can we distinguish the other cases, McCummings, et cetera, Rahman, with the fact that prior to this date, where the jury, again, is waiting outside the door of the courtroom, there was no statement by defendant that he was dissatisfied with his attorney or anything of that nature. And then after this date, when these statements are made throughout the remainder of the trial, there's nothing from the defendant, again, or from his attorney, that the defendant is dissatisfied with the attorney's representation.
No, I don't think that distinguishes this case from those cases. I'll note in several of those cases, the individual was on the second, third attorney. I think the way that this exchange ends with the denial, with the court says, I'm not going to relieve your counsel, and says, if you keep this up, we're going to have a problem. At a certain point, Mr. Cooper should not be faulted because he listened to what the court said and dropped it.
Right. So even if you have 51 prior convictions, once the court says to you, if you keep this up, we're going to have problems, that forecloses any further discussion, right?
Yes, I mean, I think essentially what respondent is arguing is that Mr. Cooper had to renew the motion, but what we're saying is that this motion essentially was wrongly denied. And it is the court's duty to protect the right to counsel. It was not on Mr. Cooper to repeatedly aggravate the trial court after the court had threatened that there were going to be problems if he pressed this. I want to specifically address the Branham distinction because I really do think Branham is on all fours. The categorical conflict of interest, if that's borne out, that requires a new counsel. That's the same thing. If you can actually prove your attorney is ineffective, you get new counsel. The question is whether the person has been allowed to say enough to make out either of those claims. So I don't think the category of error is a valid distinction.
Did he explain why he wanted a new attorney just by saying, you know, I got a field test instead of a lab test?
I don't think so, because I think the record made clear he wasn't done talking. And so, for example, on that point, if that's all he'd said, of course, mixing up two pieces of paper one time doesn't get you substitution of counsel. But if he had been about to make a record about pervasive unpreparedness by counsel, several examples where counsel was not preparing him based on the discovery for trial, that could have gotten there, and we don't know. And what this court said in McCummings is we also shouldn't speculate, because the error is that the record doesn't exist because the court wouldn't let the record exist.
Thank you.
Thank you.
Until.
You too.